Chair lays out Senate Bill 19 on second reading. The clerk will read the bill.
SB 19 by Taylor of Collin, relating to the ethics of public officers and related requirements creating criminal offenses.
Chair recognizes Representative Cook to explain the bill.
Thank you, Mr. Speaker. Senate Bill 19 is one of the most important issues that we're going to address this legislative session, and that's ethics reform. As everyone knows here in the House, the governor has declared ethics reform as one of his emergency items. Senate Bill 19 came over from the Senate, and I told members of the State Affairs Committee that I thought this was one of the most superficial efforts I'd ever seen at ethics reform, to the point that it had members, not only folks that serve in this body, but folks that may run for school board, county commissioners. Everybody's going to be peeing in a cup. And I thought it was extremely important that if we're going to take this up, that the House is going to address this in a meaningful way, so the people around the state know that we think this issue is extraordinarily important to the state of Texas. Just briefly, Senate Bill 19 deals with 4 different areas: disclosure provision, conflicts of interest, ethics and filing proceedings, vacancy of certain convictions, and recording of oral communications. So with that, members, I know there's a number of amendments, and I'm glad for us to have this debate, because once again, I'm asking members to take this issue seriously. I'm hoping that the amendments are serious in tone, because once again, I believe that the state of Texas is watching us, and we owe it to them to address this in a very meaningful way.
The following amendment, the clerk read the amendment. Speaker.
Amendment by Cook.
Mr. Stickland, for
I'd like to raise a point of order.
Bring your point of order down front. Members, we're on the Cook amendment. Chair recognizes Representative Cook.
Mr. Speaker,
Mr. Martinez-Fisher, for
before Mr. Cook gets going, I just wanted to make a parliamentary inquiry.
State your inquiry.
Mr. Speaker, under Rule 4, Section 18, Sub C, I understand that committee minutes shall be turned in within 3 days of that report. Is that your general understanding of the rule?
Chair believes that's correct, Mr. Martinez.
Mr. Speaker, thank you. Parliamentary inquiry.
State your inquiry.
It's my understanding there's a bill on this calendar being considered for second reading today, and today is the third day for those minutes to be turned in. And I know that we're sort of in an unusual situation, but typically those minutes are often made available to the body in advance of the measure coming before the floor. And I didn't know whether or not we could encourage anybody who has the custody of those committee minutes to get those turned in, timely filed, so that folks who may want them can have their access to them before that bill comes to the floor.
Mr. Martinez-Fisher, if there's a specific committee chairman you have in mind, we'll be happy to visit with him and send him your way.
Okay, Mr. Speaker, if it so happens that that committee chairman is the same committee chairman who's going to be busy on Senate Bill 19, is there somebody else I could visit with?
You could visit with the committee chairman who's responsible for the minutes you are
And
questioning.
I guess, Mr. Speaker, I'm not trying to take too much time here, but I think that the purpose of the compliance with the rule anticipates that those documents would be readily available to not only the members but to the public. And I think that maybe something to think about, something to consider, that anybody sponsoring a bill on today's calendar that does not have those minutes filed, we should discuss at that appropriate time whether or not that bill should move in order if we do not have those minutes in advance.
Thank you, Mr. Martinez-Fisher. Mr. Martinez-Fisher.
Mr. Speaker, this First Amendment is just a perfect amendment, and what it does is just eliminate multiple reportings of the same expenditures. Right now, sometimes we're having to report the same expenditure more than once because you may have not gotten your bill before you file your report, and then you got to go back and do another report. So really all we're trying to do here is just eliminate the multiple reporting to make it easier for the filers. It is acceptable to me.
Mr. Cook sends up an amendment acceptable. The author is their objection. Chair is none. The amendment's adopted. Following amendment, the clerk read the amendment.
Amendment by Cook.
Chair recognizes Representative Cook.
Okay, thank you, Mr. Speaker. This fixes a timing problem with regard to affirming tax return. It fixes a time problem with requirement that an individual affirm filings of a federal tax return. Individuals should not be required to affirm filing federal tax return for the preceding year when the tax return is due after a financial statement due. This amendment requires an individual to affirm filing the tax return that was due during the 12 preceding months. For example, if a primary candidate's financial statement is due on January 2016, the primary candidate would affirm the filing of the federal income tax on April 15, 2015. If the individual's filing statement is due on April 30th, 2016, the individual would affirm filing the federal income tax on April 15, 2016. It clarifies a good cause, including attending a legislative session. So that is good cause if you need to extend your financial report, and is acceptable to me.
Mr. Cook sends up an amendment acceptable to the author. Is there objection? Mr. Zedler, for what purpose?
Ask the gentleman a question.
Mr. Cook, do you yield a question?
I yield.
Chairman
Yeah,
yields.
Chairman Cook, let me ask you this. I didn't quite follow some of that. Let's say your personal financial statement that is due this year, like I got an extension that's due at the end of June.
That's
okay.
right.
My income tax return very often is not filed until for
Probably get an extension. and you-
2014 is
That's
not
right.
filed
And that's
off
why-
until.
And that's why this is to cover that
Okay,
situation
okay.
like you're concerned about.
Okay.
Thank you.
Mr. Cook sends up an amendment acceptable to the author. Is there objection? Chair is none. The amendment's adopted. Following amendment, the clerk read the amendment.
Amendment by Cook.
Chair recognizes Representative Cook.
Thank you, Mr. Speaker. This just inserts paid, referral fee and paid by inserting in connection with service provided by the individual. So in other words, it's not for the firm. This inures to the benefit of the individual. It is acceptable to me.
Mr. Cook sends up an amendment acceptable to the author. Is there objection? Chair is none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Capriglione.
Chair recognizes Representative Capriglione.
Thank you, Mr. Speaker. Members, this amendment has to do with the personal financial disclosure form, and what it would mean is that on your personal financial disclosure form, you'd have to list any government entities that you have contracts with. I think it's acceptable to the author.
Mr. Canales, for what purpose?
Mr. Speaker, can the author of the amendment come back? I just couldn't hear a word he
Mr.
said.
Capriglione, do you?
All right, I'll
yield?
speak louder.
Chairman
What
yields.
this is similar to the bill that we passed out of the House unanimously a short while ago, and it has to do with contracts and disclosure of those contracts on our personal financial disclosure forms.
Mr. Speaker, will the gentleman yield?
Yes.
Mr. Capriglione, do you yield?
Yes.
Can you
Gentleman yields.
specify to the body what types of contracts you're talking about?
So in terms of the types of contracts, those would be contracts that you have with the governmental entities. So if you're an elected official, and let's say, for instance, you have a contract with a municipality or so on, greater than a certain amount, then that would have to be disclosed.
And this would deal with, for instance, people that have consulting contracts and things of that nature?
I'm sorry, what contracts?
Like, for instance, if somebody has a consulting contract or something of that nature, you would have to divulge it?
Yeah, right, that's right, any written contract.
Let me ask you, can I give you a hypothetical? For instance, if you represent, or if you have a contract with somebody who represents a municipality, does that have to be disclosed?
If that contract is written and it's greater than a certain amount, that's right, you would have to disclose
And
it.
what amount is that?
Well, what we have is essentially $2,500 or $10,000 in a year. So anything over $2,500 would have to be disclosed, or anything more than.
And this deals specifically with contracts with government entities. Now, let me ask you a question. What about, I guess, any sort of financial benefits from a contract dealing with a municipality? Is that covered under your amendment?
Did you say non? I didn't hear you.
No,
You said-
anything like any sort of financial benefit that's not related to a contract.
No, it has only to do with contracts, written contracts.
And I understand this. So if there's not a written contract under your amendment, no, but you wouldn't have to disclose anything.
I can't think of any reason why a government entity would give cash or money to someone that's not in a contract. I would hope that they're not doing that.
You and I both. I think you've got a great amendment. Thank you, Representative.
Thank you very much.
Ms. Marquez, for what purpose?
Mr. Speaker,
Ms. Marquez, for what purpose?
Representative Capriglione, will you yield for
Capriglione, do you
some
yield for
questions?
question?
Yes.
Gentleman yields.
So let me understand this particular amendment. This amendment is requiring those entities or companies that have a contract with any kind of governmental body or political subdivision is required to file a personal financial statement.
So everybody who today has to file a
Not
personal-
everybody.
No.
Not everybody today.
Not everybody has to file a personal financial disclosure form, but those that do have to file a personal financial disclosure form that have a contract with a governmental entity that is larger than the amount that's listed in this bill would have to disclose that.
So if a municipality entered into a contract, correct, for the building of something, a city garage, or who would have to file the personal financial statement in this scenario?
If there's no elected official in the contract, then no one has to file a personal financial disclosure form
But if it
anyway.
if the contract was entered into by a resolution or a vote by a particular governmental body, would they have to file a personal financial statement in order to enter into that contract?
I do not increase under this bill any amount of personal financial disclosure form requirements. If you currently have to file a personal financial disclosure form, then you would have to report it.
What about a political subdivision such as a school district?
School districts don't file personal financial forms.
So this wouldn't require them to file, even though they're deciding on $1 million contracts every month?
The school
Year.
does not. That's a different bill.
So this is only pertaining to those that already file personal financial statements. You're just creating a qualifier, which is the 2,500 or 10,000.
I think that's what I've said a few times, yes.
I can still ask questions.
I
Thank
know.
you, Representative.
I can still answer them.
Capriglione.
Thank you.
Mr. Speaker,
Mr. Anchia, for what purpose?
will the gentleman yield for
Mr.
questions?
Capriglione, do you yield for question?
Yep.
Gentleman
So
yields.
I'm a little unclear on subsection E of your amendment.
Okay.
Why did we exempt disclosure, from disclosure, an employment contract between a school district or open enrollment charter school and an employee? What was the thinking behind exempting that type of a relationship?
So in the case of a teacher, for instance, they do sometimes have a contract with the school district, and so that could be considered personal confidential information. So after hearing from different stakeholders, we thought it best not to have to disclose the salaries of individual teachers.
I see, I see. But wouldn't that be only for a person who who would serve in the legislature, for example? You wouldn't have that situation arise, correct?
No, because what this does is, in terms of the degrees of relationship between who has to file a personal financial disclosure or not, it could also be if someone's spouse is a teacher.
All right, so you're talking about a spouse. Okay,
right.
okay. And in section 15, which is the second provision in your amendment, when we're talking about the selling of costs, the aggregate cost of goods or services sold, and having a $10,000 per year threshold, or a contract of $2,500 or more, does that only apply if the political subdivision is paying the person providing the goods or services rather than the other way? So if money is going the other way, would they need to still would they still need to disclose?
You're right, and I do want to talk about this amendment. So in this amendment, that's what it does. There is another bill that just passed the Senate that would go the other way, but this particular bill is only on contracts between a governmental entity and someone that files a personal disclosure form.
Got it. And where the money is going from the governmental entity to the person providing the goods or services.
That's right.
Okay. Thank you.
Thank you. I think that's cool.
Mr. Speaker,
Mr. Rodriguez, for what purpose?
will gentleman yield for a few
Mr.
questions?
Capriglione, do you
I
yield?
will.
Representative, question on this. For a contract for goods and services, is it a contract with an entity? Can it be considered with an entity outside of the state of Texas, or only a governmental entity or an entity in Texas?
That's actually a good question. So the point of this
Thank
is
you.
really, you're welcome. The point of this is really for those things that we have some authority over. So it would only be related to things.
Mr. Bell
inside the
raises
state.
a point of order. The gentleman's time expired. Point of order is well taken and sustained.
Okay.
Mr. Capriglione sends up an amendment acceptable. The author is objection. Chair is none. The amendment is adopted. Following amendment, clerk read the amendment.
Amendment by King of Parker.
Chair recognizes Representative King of Parker.
We have it? Yeah. Mr. Speaker, members, thank you. This amendment, which I think is acceptable to the author, just corrects a couple of things that were kind of in conflict with state bar rules. It corrects on page 12. There's a section that says that if you're doing government contract consulting services, which means to advise or assist a person or an entity in maintaining or applying for, soliciting, or entering into a contract with some government agency, that you have to reveal the name of the person that you're doing the services for and what they paid you to do that. And the problem for an attorney, attorneys are prohibited under the state bar rules from due to client confidentiality. So, for example, in the case where you're helping a roofing contractor draft a contract so that he can bid for the contract to re-roof some city or county building or something like that, we would not be able to put that on the financial statement of who our client was. So simply all this says is that it says that this term, this definition, consulting services, does not include services provided for in the normal course of providing legal services. So that's the First Amendment. The other section, there's a section on the ethics counselor, and it required the ethics counselor to this new entity to produce a report 30 days after session that was an analysis of each person's financial statement and any concerns over where you might have conflicts, and then that would be a public report. The problem with that was you would have probably been filing bills several months before that, and in addition, you may have been placed on a committee. And say, for example, that, and there's no way to appeal that and say, well, just because I have stock in Exxon, for example, doesn't mean I shouldn't get to serve on the Energy Committee. So this instead, I think, addresses what is the real problem that we've all faced, is that we've called the Ethics Commission, all of us have done this, and said, hey, if I do this, is this fit within the rules, or if not, is it some kind of violation? And they can't tell you. This instead amends to instruct the ethics counselor to be available to members 24/7 before and through the session, and to be able to give an oral or a written opinion anytime you call to help you understand whether this would fit within our ethics rules when we have those questions, or maybe a conflict of interest, which I think is the real problem that we all have, is sometimes we can't get anybody to give us an answer on this, and this would require that. The third thing that it does is there's a section on page 21 or 20 and 21 that prohibits attorneys from receiving referral fees and from their firm doing so. Well, I'm in a small firm, so it really doesn't hit me, but members that work for large firms that maybe even be multi-state, they have no idea if other attorneys in the firm are receiving referral fees and things like that. And so instead, what this simply says, it's a very firm, we have the Texas Bar Rules, the Rules of Professional Conduct, which we get disciplined for, have a very strong and clear and elongated statement of when attorneys can receive referral fees and when they cannot. And I'll just tell you, I hadn't received one in years and years and years, so this really doesn't hit me. But what this simply says is that any attorneys in the legislature are required to strictly adhere to the rules of professional conduct, and that they can only receive monetary compensation if it complies with the professional and ethical conduct as set out by the Texas Bar Association. And so that is the amendment in a nutshell. I'll be happy to answer any questions.
Mr. Turner, for what purpose?
Would the gentleman yield for a question?
Mr. King.
Absolutely.
Gentleman yields.
Right. Thank you, Mr. King, and I appreciate the detailed layout of your amendment. And I'm not a lawyer, so I don't even understand all the referral stuff. But I did have a question on the ethics counselor, and I did want to, at the appropriate time, ask Chairman Cook a little bit about this too, just to better understand the concept. But what your amendment does, it says you want the ethics counselor to be available to members of the legislature going into session, during session, after
Absolutely.
session.
And to have the freedom to actually give an opinion, which the Ethics Commission doesn't have the freedom to do.
Right. And is your intent, and maybe if you can speak to it, the bill's intent, is it that the ethics counselor proactively analyzes situations members may be in and then proactively reaches out to us and says, hey, Representative Turner, you may want to look at this, you may have a potential conflict here, or is it something simply that's a passive reactive actor that we reach out to when we feel the need to, but otherwise he or she does not engage?
I don't think the bill initially has them reach out to us. I think what it has an ethics counselor do is research everyone's financial statements, and after we're already in session 30 days, then produce for each member something where it says, hey, you may have a conflict of interest financially here. Problem is that's way too late in the session to do that. And there's what I think what we're really needing, at least what I've always needed as a member, is to have some place that I can call who has the authority to give me an opinion on the spot if I've got a possible conflict of interest on a vote or on an investment, a business deal, anything, that I can get an immediate oral or written opinion, and that I then have the authority the freedom under this amendment to release that publicly so everybody knows that I went out and got an ethics opinion.
No,
and that's what I'm trying to do.
I think that's smart. So your amendment wouldn't change the intent of the bill for the ethics counselor to analyze all the reports and then provide this report. They would still do that, but then we would have the ability to.
I believe that the amendment would strike that section of the bill.
It does strike that section.
It does.
Okay.
And instead puts them in a place of being basically our legal counsel that we can go to, and then when we get an opinion, we can publish that.
Okay. So under your amendment, we would strike their sort of proactive role in the process. And I'm not necessarily disagreeing with that. I'm just trying to understand.
They will still have the full ability to go and analyze everything on their own as they feel necessary to do that. But they would be available for the members to go to.
But they would not be required to create this report.
That is correct.
Under your amendment.
That is correct.
Okay,
to be honest, I'm not sure how they can create that report when we don't have enough information in the financial reports for them to be able to do that without a lot of further research and delving into it. So it just seemed like it was non-functional, and I'm trying to make it functional and beneficial.
Yeah, I understand. Do you know under the bill how the ethics counselor is appointed? I may have missed it in Chairman Cook's layout.
No, I don't. I'm sorry. You'd have to ask the author that.
Okay, when he's back up, I'll try to speak to him on that question.
Thank you. Thank you for your questions, too.
Thank you.
They were good questions. Mr. Speaker, I believe this is acceptable to the author, and I would move for adoption.
Mr. Turner? Would Chairman Cook be available just to answer that quick question as he accepts this amendment?
Mr. Cook, do you yield?
Yes. The Ethics Council will be appointed within the Legislative Council, has to be an attorney. I actually think this is one of the most important pieces of this legislation, because I think all of us want to stay within the ethical guidelines of where conflicts of interest are. And it's real hard for any of us to know. So having somebody that's at Leg Council that can give us guidance on what might be appropriate to be involved in or not, I think will be a big benefit to this body.
Sure. I understand. And so be an employee of the Legislative Council, would they be appointed by the Executive Director of the Legislative Council?
Yes, they would be appointed, there within Legislative Council. Exactly right.
And if my memory serves, am I correct that the Executive Director is an appointee of the Speaker and the Lieutenant Governor? Is that still the case?
I think that's the case.
Okay. Thank you, Mr. Chairman.
You're welcome.
Ms. Schaefer, for what purpose?
Will the gentleman yield for a question?
I yield.
He yields.
Mr. Chairman, you know that Senate Bill 11 dealing with campus carry, and Senate Bill 575, a pro-life bill dealing with abortion coverage and insurance, are on the calendar today. Would you be willing to postpone this bill so we can reach those important matters?
You know, I'm hoping what we can do is finish this bill.
Well, I think there's a lot of amendments, and I think this may be the last bill we hear today. Would you be willing to postpone this bill so we can take up the pro-life bills?
I hope we can get through this bill.
That's not about the bill.
Mr. Speaker,
Ms. Tenderholt, for what purpose?
I move to have that conversation reduced to writing and placed in the journal.
Members, you heard the motion. Or any objection? Chair hears none, so ordered.
Yeah, no, good.
Representative King, the gentleman's time has expired. For what purpose, Ms. Howard?
Parliamentary inquiry.
Please state your inquiry.
Is the ethics bill listed on our calendar as an emergency item?
Yes, ma'am.
So it's an emergency item. What does that mean?
It means that it's been set by the calendars committee as an emergency item.
And it's been set as an emergency item instead of major state because it's an emergency item. Am I missing something here, or do you need to explain to me what that means when it says emergency?
Pursuant to the calendar system and Rule 6, calendars have different settings. One of those being emergency. Pursuant to Rule 6, Section 7, subsection 1, is a designation of the emergency calendar. The clerk will now read that.
Emergency calendar on which shall appear bills considered to be of such pressing and imperative import as to demand immediate action, bills to raise revenue and levy taxes, and the general appropriations bill. A bill submitted as an emergency matter by the governor may also be placed on this calendar.
So, Mr. Speaker?
Yes, ma'am.
Which part of that definition does this bill apply to?
You should probably have a conversation with Chairman Hunter and the reason they set that.
Well, Mr. Speaker?
Yes,
may
ma'am.
The real question here is if it's an emergency item, and if the calendar means anything at all, and it is placed on the calendar as an emergency item because it is so critical that we pass this, then why would we not consider the emergency item when we finally arrive at it in the calendar since it's an emergency?
Thank you, Ms. Howard.
Mr. Speaker.
Mr. Anchia, for what purpose?
Parliamentary inquiry.
Please state your inquiry.
Was ethics not an emergency item of the governor that he laid out previously?
Yes, sir, it was.
Okay. And it might stand to reason that that's why we have it on the emergency calendar? Thank you.
Could be one possibility, yes, sir. Mr. King offers up an amendment. It is acceptable to the author. Are there any objections? Chair hears none, so ordered. Following amendment, clerk will read the amendment.
Amendment by Canales.
But please excuse Representative Dale and Larry Gonzalez because of local consent on a motion by Representative Sheets. Chair recognizes Mr. Canales.
Thank you, Mr. Speaker, members. What my amendment does is on page 12, line 7, it strikes B and substitutes affirmation of property tax payments. And what this does is under 57.2.035, the submission of a federal tax return, and it creates each member of the legislature shall submit the member's most recent federal income tax return to the commission not later than the August 31st of each year. And the information contained in that tax return, other than is information is confidential under 552.117, is public information. And so the long and the short of it is it's just a transparency amendment.
Chair recognizes Chairman Cook to oppose the amendment.
Once again, the reason for what we're doing here is to ensure that we don't have conflicts of interest. And filing a federal income tax return does not rise to that, and I would ask everybody to vote no on this amendment.
Mr. Canales, for what purpose?
For the gentleman yield.
The gentleman yield.
I yield.
I had trouble hearing you, Chairman. The reason for asking the body to vote no on this amendment, your reasoning, I didn't hear it.
What we're trying to determine whether we have conflicts of interest. That's why we have a financial statement. That's why we have, in this an ethics advisor, counselor, and once again, filing a tax return is not something that is necessary. By the way, I'd like to point out, too, that we are citizen legislators. So unlike the folks you send to Washington who are paid a lot of money and work full-time, we work on a part-time basis for basically nothing. So this is not something that would be appropriate to this bill. And,
okay, and to some degree, I agree with you. Would you agree with me that anything on your tax return that may potentially have an effect on your decision in the legislature maybe would be of interest?
Once again, that's why we have the financial statements, which everybody files every year. That's why we now would have an ethics counselor that can address that. So once again, this is not something that would be necessary. And by the way, amendments like this would probably result in less people willing to come serve, because once again, we're citizen legislators. We're not paid to do this. So I don't think it's appropriate.
Thank you, Mr. Speaker.
Mr. Canales, for what purpose?
I'd like to respectfully withdraw the amendment.
Mr. Speaker.
Ms. Stevenson, for what purpose?
Just a question to tell the actual due date of your tax return final is October the 15th.
Mr. Stevenson.
Thank you.
Please excuse Representative Clardy, Burkett, Sheets, Capriglione, Isaac Munoz for Local and Consent Committee on a motion of Mr. Anderson of Dallas. Members, this is a 1-hour notice that Representative Simmons intends to make a motion to reconsider the vote by which SB 1496 was defeated. Following amendment, clerk will read the amendment.
Amendment by Alonso.
Chair recognizes Mr. Alonso. Chair recognizes Mr. Alonso.
Okay, members, what this amendment does is one of the ways that our constituency groups, like teachers, ARP, are able to communicate with us is through robocalls. It's an inexpensive way that they're able to, so this amendment says they would still be allowed to do that.
Mr. Alonso offers up an amendment. It is acceptable to the author.
Mr. Speaker.
Mr. Bernal, for what purpose?
Does the gentleman yield for a question?
Author of the amendment, author of the bill.
Author of the amendment.
Mr. Alonso, do you yield? Not at this time.
Sorry, Mr. Bernal. Thank you.
Mr. Alonso offers up an amendment. It is acceptable to the author. Are there any objections? Chair hears none, so ordered. Following amendment, clerk will read the amendment.
Amendment by Rodriguez of Travis.
Chair recognizes Mr. Rodriguez.
You see this?
Thank you,
Mr. Rodriguez.
Thank you, Mr. Speaker, members. SB 19 currently states that personal financial statements are public records. It also states that the Commission must maintain the statements in a separate alphabetical file and in a manner that is accessible to the public during regular office hours. The Commission also must make the statements available in a searchable format to the public on the Commission's website not later than the 3rd business day after the date the statement is required to be filed or is actually filed, whichever is later. So this amendment, members, simply states that the searchable format named in the bill must be published on the Internet using an electronic form that allows people to search the fields and the data that has been entered, such as a spreadsheet. The difference basically between searching an Excel, Word, or HTML document versus a PDF. So it allows you to more options there. And with that, it is acceptable to the author.
Mr. Rodriguez offers an amendment. It is acceptable to the author. Are there any objections? Chair hears none, so ordered. Following amendment, clerk will read the amendment.
Amendment by Rodriguez of Travis.
Chair recognizes Mr. Rodriguez.
Thank you, Mr. Speaker. Remember, this amendment addresses the reporting requirement for a split expenditure or the practice of buying down to avoid a detailed report. It says that if more than one registrant collaborates together to make an expenditure of which the total value of the benefit conferred exceeds the $50 per person per day, each shall file a detailed report regarding the expenditure. Additionally, the amendment adds a requirement that the Texas Ethics Commission notify a legislator or member of the executive branch in the event that they have reached or exceeded the annual limits allowed by lobbyist expenditures, such as gifts and entertainment. I believe it is not acceptable to the author.
Chair recognizes Chairman Cook to speak against the amendment.
Members, I'm going to respectfully speak against this because in the bill, what we say it'd be 50% or 60% of the legislative per diem as decided by the Texas Ethics Commission. To be honest with you, I don't want members deciding what they're going to get paid. I would much rather set the parameters and have the Ethics Commission tell us what would be appropriate. So with that, I would ask you to vote no on this amendment.
Chair recognizes Mr. Rodriguez to close on his amendment.
Thank you, Mr. Speaker. Members, I just think if we're going to try to do this ethics reform, that we need to go do what we should be doing. And really, this is a pretty simple amendment. It just says that when more than one registrant collaborates together to make an expenditure of which the total value of the benefit conferred exceeds $50 per person per day, that each shall file a detailed report regarding that expenditure. So if we're going to try to limit it and we want to report it, then we should have each one of them reporting it individually.
Mr. Turner? Would the gentleman yield for a question?
Does the gentleman yield?
I yield.
He yields.
Thank you, Mr. Rodriguez. Let me make sure I understand your amendment. Essentially, you want to say if an expenditure is greater than $50 at a time, then it has to be disclosed? Is that the essence of the amendment?
But also that if it's more than one person in the aggregate, that's $50 that each individual would have to also file, so that we have a full picture of what that expenditure or gift or entertainment or whatever that is.
Right.
We have
We're
a
talking
full
about
picture.
We're talking about lobbyists, right? I mean,
correct.
We're making lobbyists file. I don't want to represent someone's legislation in a way that's not accurate, but I thought Chairman Guerin had a bill that addressed this. Is this similar to what was in his proposal?
It's similar. I think the dollar amounts are different, but it's a similar concept.
Similar concept.
Yeah, absolutely. And we passed that. I believe we passed that bill earlier. Did we not?
I'd have to ask Chairman Guerin to be sure. I know we passed a number of his ethics bills. I can't recall offhand if that's been one of them so far.
Right. So this is kind of a kind of a belts and suspenders approach. We've done something like this before. If we want true transparency, let's go ahead and do that, and that's what the spirit of this amendment is.
Right. Because right now, am I right that this amount that can be spent prior to disclosure is around $100, or a little more than $100?
I think it's a little bit more than $100. Yeah, like $115.
And essentially, you would lower that to $50 with this amendment.
Correct. And also, if it's more than one individual, that together it's $50 or more, that each individual would have to report as well.
Yeah. I think you have a great amendment, and I hope the body will support it.
All right. Thank you. Thank you, Mr. Speaker. Members, please consider this. If we want to be transparent, we want ethics reform, I believe this amendment makes this bill a lot stronger. Stay with me, members, and please vote aye on this bill, this amendment.
Mr. Rodriguez offers an amendment. Mr. Cook, we'll leave it to the will of the House. Members, this... Members, this is an up or down vote. Mr. Cook will be voting no. This is a record vote. Clerk will please ring the bell. Show Mr. Villalba voting no, Mr. Cook voting no, Mr. Murphy voting no, Mr. Rodriguez voting aye, Mr. Oliveira voting no. Have all voted? Have all voted? Being 57 ayes, 82 nays, the amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Guerin.
Chair recognizes Chairman Guerin.
Thank you, Mr. Speaker. Members, this amendment reinforces what most legislators believe currently exists every time they communicate. This protects our communications with Ledge Council as being private, and it's acceptable.
Mr. Guerin offers up an amendment. It is acceptable to the author. Are there any objections? Record vote has been requested. Record vote is granted. Clerk will please ring the bell. Show Mr. Cook voting aye, Mr. Villalba voting aye, Ms. Davis of Houston voting aye, Mr. Sheets voting aye. Have all voted? Have all voted? 115 ayes, 23 nays. The amendment's adopted. Following amendment, clerk will read the amendment.
Amendment by Rodriguez of Travis.
Chair recognizes Mr. Rodriguez.
Thank you, Mr. Speaker. Remember, this amendment requires a lobbyist to file a detailed report listing the amount of an expenditure and the legislative or executive branch individual who benefited if the expenditure exceeds $50 per individual per day. The lobby expenditure cap per individual per day is currently tied to the legislative per diem, 60%, and that's about $114. This amount removes this link to the per diem and sets an amount equal to the current requirement for detailed reporting as a gift. This bill also requires a detailed report for an expenditure over $50 per person per day that is made by lobbyists for the benefit of an immediate family member or a member of the legislature or executive branch. Lowering the threshold increases transparency by providing the public with information about the activity taking place between elected officials and lobbyists and restores meaningful disclosure to the activity reporting requirement.
Mr. Bernal, for what purpose?
Does the gentleman yield?
Gentleman yield.
I yield.
Representative, I know that you're reading right off of your sheet, and I think that your amendment is actually an interesting and important one. I'm wondering if you could walk through it. To me, it sounded like a nightmare LSAT prompt, but I think that considering where we are and who we are, it has some very practical effects and ramifications. I'm wondering if you could break it down into nuggets and explain to the body exactly what you're trying to do and how it works.
Yes, yes. So basically what we're doing here is a couple of things. One of the main things is right now, what the expenditure cap is per individual lobbyist is, it's tied to our legislative per diem, and that at 60%. So it's tied, there's a direct tie to our per diem versus just a dollar amount. So because it's tied to 60% of our per diem, 60% of our per diem, this session anyway, is $114. So what we want to do with this amendment, Representative Bernal, is to basically say that we want to just make it a flat $50 or more. If it exceeds $50 per individual per day, that gets reported. The other thing that it does is if there's a $50 expenditure to benefit or that benefits a family member of a member of the legislature or a family member of a member of the executive branch, that also must be reported. So it's a matter of transparency, but also kind of divorcing the amount of expenditure per individual per day, divorcing that from our per diem pay and just kind of doing it as a simple over $50 amount.
Ms. Turner, for what purpose?
Yeah, well, Representative Rodriguez, come back just for a quick question.
Mr. Rodriguez, do you yield?
I yield.
Yeah, just for clarification purposes, your amendment is saying that the reporting must be done for $50
or more.
Or more.
Yes, to an individual, to a member of the legislature, or a family member of the legislature, or a family member of the executive branch.
And just for clarification purposes, what is the limit now?
The limit now is $114 because it's tied to our per diem, and so it's 60% of our per diem, which equals $114. And so what this does is divorces it from that, the marriage of the tie that we have with our per diem as far as the expenditure goes, to just kind of a flat over $50 amount and not really having it be related to our per diem at all.
Okay, and the purpose would be to, what are we trying to achieve?
Well, what I'm trying to achieve is just, a little bit more transparency, just trying to actually lower the amount that they can spend. That's really what it is for me.
Okay.
Yeah.
Will the gentleman yield? Mr. Speaker?
Ms. Gonzalez, for what purpose?
Will the gentleman yield?
Does the gentleman yield?
I yield.
Thank you, Representative Rodriguez. I have two questions. Since we're going to change from it being tied to our per diem to a $50 flat rate, why was it previously tied to our per diem? Do you know the history and background?
That's a good question. I'm not really sure. I'm not sure that at all why that is. I don't see any connection there on what you spend versus what we would earn during the legislative session, personally. So
Thank you.
I'm not sure why that was ever tied to it.
I just want to see if there was a reason that maybe I just didn't understand that we're going to change this process, but I don't know if there was an intentionality around that. My second question is, you talk a little bit about transparency, and so that the public could know. How would the public know now if there was a gift given to a legislator that was over that amount?
Well, currently, that information has got to be registered with the Ethics Commission, and that is made public. I'm not exactly sure on the timing of it. There's some other things in this bill and some amendments, I think, that would make it so that it's online, very easy to find, that it's available to you as soon as, maybe even the next day or, as soon as possible in different formats. And so Right now, I think it's available, probably available online, but I'm not sure about the timeliness of it.
Oh, but it is available online?
I can't speak to that for sure. I don't know.
Okay, well, thank you, Representative Rodriguez.
Thank you.
Chair recognizes Chairman Cook to speak against the amendment.
Thank you, Mr. Speaker. I am going to speak against this amendment. The committee sub in front of you tells the Ethics Commission to set this. This should be their job and not ours. Substitute Senate Bill 19 creates a range in which the Commission has to set the detailed reporting threshold from a minimum $50 to 60% of whatever is the per diem, which is what we have today. And I believe the best place to make this decision is not with us, but with a third party, which is the Ethics Commission. For that reason, I'd ask you to vote no on this amendment.
Chair recognizes Mr. Rodriguez to close on his amendment.
Thank you, Mr. Speaker. Members, this amendment is really quite simple. I don't know exactly why the expenditures was ever tied to our per diem. I mean, we can probably guess here, but I don't see any real relevance to why those two things should be tied together. This simply just separates that. It's a $50 or more that is going to be has to be reported, and I think it's a matter of transparency, and it just makes, I think, good ethical sense. So with that, members, I hope that you would vote in favor of this amendment.
Mr. Rodriguez offers up an amendment. Members, this is up or down vote. Will of the House. Clerk will please ring the bell. Show Mr. Cook voting no, Mr. Patty voting no, Mr. Villalba voting yes. Have all voted? Have all voted? Being 57 ayes, 81 nays, the amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Sheets.
Chair recognizes Mr. Sheets.
Thank you, Mr. Speaker. Members, if you look on your screen, you'll see the amendment. This was a bill that we actually passed out of the chamber on the last day that we had a deadline. You may remember the debate that we had on this. This is the...
Mr. Canales, for what purpose?
I will yield in just one second, sir.
Yes, sir.
This is the bill that says, and it's now an amendment, that if you're an elected official convicted of certain felonies associated with your official conduct, that you forfeit your pension, and I'll yield to Mr. Canales.
Mr. Sheets, I was looking at your amendment on the iPass system, and I've been noticing that people have been handing out posters where everybody can sign, and I was wondering if I might be able to get a copy of the original so that I can frame your amendment, because it looks like you've got every member of the House.
Well, we got a lot of them.
I like it. Is my name on that?
Your name is on here, and if the membership remembers, last time you and I had a very spirited debate on this amendment.
And I liked it then, and I like it now. Thank you.
Speaker, will the gentleman yield? Will the gentleman yield?
Does the gentleman yield?
I'll yield.
Representative Sheets, I'm glad to see that you might have added a couple more causes of action or crimes in here, have you not?
I incorporated yours and Mr. Moody's amendments into it.
Well, very good. Well, thank you. I understand from your original that there are substantially more penalties and crimes in here, so I appreciate it, including abuse of official capacity. So you seem to have a good amendment. Thank you.
Thank you, sir. And I believe the amendment is acceptable to the author, and I would move passage.
Mr. Speaker?
Ms. Giddings, for what purpose?
Could I ask the gentleman a question, please?
Do you yield, Mr. Sheets?
I yield.
He yields.
Same question I had when we talked about this before. Spouses, this being a community property state, are not affected by this, right?
That is correct. Yes, ma'am. We put the provisions in there to protect the spouse's interest in the pension.
Thank you.
Thank you, ma'am. Move passage.
Mr. Sheets offers up an amendment. It is acceptable to the author. Are there any objections? Chair hears none, so ordered. Following amendment, clerk will read the amendment.
Amendment by Canales.
Chair recognizes Mr. Canales.
Members, this is a tightening up the language of a determination of substantial interest. I've spoken with the author, and this is the one that said it was acceptable. It just basically clears up what a substantial interest is with respect to ownership that would be declared.
Yeah.
Mr. Canales offers up an amendment. It is acceptable to the author. Are there any objections? Chair hears none, so ordered. Following amendment, clerk will read the amendment.
Amendment by Rodriguez of Travis.
Chair recognizes Mr. Rodriguez.
No, I haven't. Thank you, Mr. Speaker. This amendment changes the contract reporting requirement for lobbyists so that they must report their compensation in increments of 5,000. Currently, lobbyists only have to report ranges of compensation. The most common ranges are so large they don't tell us really anything, from 25,000 to 50,000, or from 50,000 to 100,000. I don't know about the rest of y'all, but the difference between 25,000 and 50,000 is pretty steep. And the same can be said for the difference between $50,000 and $100,000. So current reporting requirements just don't tell us enough. There's not sufficient transparency. You can't really know what that specific amount is, or within a more reasonable range. So again, members, this is about transparency. It just kind of it lowers the range increments of $5,000 versus $25,000. Or $50,000, and I believe this is a good.
Mr. Speaker, would the gentleman yield?
For what purpose? Does the gentleman yield?
I yield.
Thank you, Mr. Speaker. Representative Rodriguez, I looked at this before as well and looked at what they do at the federal level. Do you know what the increments of income are at the federal level that they're looking at?
I'm not aware.
I believe it goes up to $5 million.
Oh, wow.
So what you're talking about here is only $5,000 more, is that correct?
It's 5,000, yeah, going in increments of 5,000 versus 25 to 50, 50 to 100, and et cetera.
But up 5,000.
Right, exactly right.
And so
instead of, say, between 25 and 30,000, or between 35,000 and 40,000, that kind of thing.
Right, so what you're talking about is a small incremental amount, but it would take us in the right direction when you're talking about, if we were going to mimic what they're doing at the federal level, of $5 million,
right.
We're still significantly below that. And still, if we're trying to get information that is going to tell us what sources of income legislators have, not because there's a finite line that should or should not be crossed, but because voters deserve to have that information so that they can then make a decision about whether or not they think, as voters, that there's some kind of a potential conflict of interest. Is that not correct?
Correct, yes.
So what you're trying to do here with your amendment is just take it a little further down the road here so that we actually have greater information. But do you know how long this has been in effect, the current categories?
I'm not sure, but they're pretty. There's a pretty large gap within these ranges, and so I just think for me this is about transparency and getting really a clearer picture on what what's out there, right? So we should all know that, and for our constituents to know this information.
I think it's a good amendment.
Yeah.
Thank you.
Thank you.
Chair recognizes
I'm going
Mr.
to
Cook.
speak against this amendment. This bill is already providing a lot more transparency than we had, and this is kind of a de minimis, so I would ask that you vote no on this amendment.
Chair recognizes Mr. Rodriguez to close on his amendment.
That's a different one. That's this one. Thank you, Mr. Speaker. Again, members, this bill, I believe, was about a lot of different things, but I think transparency is definitely one of them, and this is really simple. Let's just fix these ranges of reporting and compensation to a more reasonable amount of $5,000 versus a large gulf of 25 to 50 and 50 to 100, et cetera. So that's really what I'm trying to do here. It's just more transparency so our constituents and the public in general know a little bit more. So I ask you to vote for this amendment.
Mr. Rodriguez offers an amendment. Members, this is left to the will of the House. Vote up, vote down. The clerk will ring the bell. Mr. Villalba voting no. Mr. Murphy voting no. Mr. Cook voting no. Mr. Meyer voting no. Ms. Dukes voting aye. Mr. Canales voting aye. Have all voted? Have all voted? Being 56 ayes, 81 nays, amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Meyer.
Chair recognizes Mr. Meyer.
Mr. Speaker, members, this is an amendment that is a bill that passed 138-0 in the House and just increases the penalty for insider trading. And I believe that this amendment is acceptable to the author. I move adoption.
Mr. Meyer offers up an amendment. It is acceptable to the author, and the interjection. Chair hears none, so ordered. Following amendment, clerk will read the amendment. Anybody among it?
Amendment by Dutton.
Chair recognizes Representative Dutton. Chair recognizes Representative Dutton.
Thank you, Mr. Speaker. Members, what this amendment was attempting to do, and as I read the bill, I didn't see it, but Chairman Cook has just told me his language in the bill is designed so that appointees made by the governor have to fully disclose their contributions to the governor. And I believe that's right, and it's in any amount. It doesn't matter. Okay. Because one of the things that concerned me was the perception is that you had to pay to play in terms of gubernatorial appointments. And while that may not have been the reality, the perception, at least on the part of a number of people, was the case. Because when I looked at for example, the different state agencies, and I looked at the amounts that were being contributed to the governor's office, it was interesting to me that, for example, the Parks and Wildlife, the average contribution per appointee was $118,000. When I looked at A&M regions, it was $113,000. University of Texas regions, it was $83,000. And so that, to me, gave the appearance that it was a pay-to-play arrangement, at least perceptually anyway. And so that's what my amendment was attempting to do. But since Chairman Cook has taken care of that in his bill, I will withdraw my amendment at this time.
Following amendment, the clerk will read the amendment. Representative Canales.
Amendment by Canales.
Chair recognizes Representative Canales.
Mr. Speaker, members, basically what this bill currently states is that members of the legislature who are convicted of felonies lose their seat. What this amendment adds, the governor and all other statewide officials in this section, it specifically states that the governor and statewide officials will be held to the same expectations. I believe it's acceptable to the author.
Members, Representative Canales offers up an amendment. The amendment is acceptable to the author. Is there any objection? Chair hears none, so ordered. Following amendment, the clerk will read the amendment.
Amendment by Anchia.
Chair recognizes Representative Anchia.
Thank you, members. I'm going to temporarily withdraw this amendment. I think Representative Canales' amendment may have preempted it. I just want to figure that out. Thanks.
Representative Anchia temporarily withdraws the amendment. Following amendment, clerk will read the amendment. Mr. Schaefer.
Amendment by Schaefer.
Chair recognizes Representative Schaefer.
Thank you, Mr. Speaker. Members, if we're going to work on this bill, let's work on it. This amendment makes sure that we don't treat legislators differently than we treat everybody else. There's a provision in this bill that says we're going to eliminate the two-party requirement for recording but only for legislators in the Capitol. Whether you think that's good or bad, I don't know. But if we're going to do it, it ought to apply to every member, every person in the state of Texas. People in corporate America who care about protecting their privacy and their proprietary information. People in city councils, in county commissioners' courts, in courts all over the state. Shouldn't just apply to us. People get disgusted back home when we come down here and we carve out rules that protect us from being recorded. This amendment will strike it.
Will the gentleman yield for some questions?
Does the gentleman yield for questions?
Yes.
Gentleman yields.
Representative Schaefer, I can tell you've been working up to this. Let's back up a little bit. So what we're talking about is permission to record individuals. So certain states have certain parameters on how many parties need to know that that's being recorded, correct? Is that what we're talking about?
Sure.
Generally, the broad issue.
Sure.
So in Texas today, if I want to record a conversation between you and myself on the phone or anywhere else, if I know I'm recording it, that's okay under Texas law, right? You don't have to know.
That's my understanding.
You don't have to know. Now, other states have adopted rules that say both you and I must know and consent to that recording. Isn't that correct?
Sure.
Do you know how, well, is it or does it, other states have that two-party rule, right?
Yes.
Okay. So how long has the rule in Texas been in effect that, I guess this bill changes and there's a specific carve-out that's in this bill? Is that what you're drawing attention to?
Yes.
Okay, and can you cite to it? Was that something that was in the original file bill?
It's on, I believe this provision came over from the Senate. And
this was a Senate amendment?
I think it was, but, it starts on page 28, or 27 rather, and runs, this section of the bill. I'm not sure. I don't know that I can accurately say whether this was included in the Senate version or it was added in the House, but I know it's in the bill before us today.
Okay, all right. I'm just trying to, because I know this bill has been in the works for quite some time, so I'm trying to figure out exactly which component we're drawing attention to. So I guess what your position is if we're going to create a two-party consent requirement.
Stand by one.
Okay.
Members, we're going to back up for a second and resolve this. Members, the previous amendment is withdrawn. The following amendment, the clerk will read the amendment.
Amendment by Schaefer.
Chair recognizes Representative Schaefer.
Sorry about that. Members, we had a mix-up on which amendment we had in front of us. I yield for questions to my friend Joe Moody.
Representative Moody, for what purpose?
Are we on a different amendment?
We're on a different amendment.
Okay, I'll allow Representative Schaefer to lay out the
It's the same one. It's the same topic. Same one I was talking about. We had an error on the first one.
You got it. Okay. Oh, we had the wrong one in the queue. Is that what happened?
That's what happened. Would you like the gentleman to yield?
Yes, would the gentleman yield?
Does gentleman yield?
I'll yield for some questions.
Gentleman yields.
Okay. Now, do we both consent to having a conversation about this amendment?
We do.
You get that? Okay. So this piece of the bill it pertains specifically to legislators or anyone that's employed in the Capitol?
It says communications.
Or the piece of the bill that you're trying to strip out.
It says that communications with the legislature or the lieutenant governor or a person, legislature or the lieutenant governor.
So legislator, House members, senators, and the lieutenant governor? Is the governor included in the provisions of the bill?
Excuse me?
Is the governor included in the provisions of the bill, or any other of the statewide elected officials?
I'd have to cite the bill. The bill says a party, it refers to a member of the legislature or lieutenant governor. So it doesn't, I don't see where it lists the governor.
Amendment.
So this is, and again, this is talking about within the confines of the Capitol only?
I don't know that it says the Capitol grounds. It just says communications with legislators or lieutenant governor while in the state capitol.
Okay.
Yeah, while in the state capitol.
Okay. And
But the point here, Representative Moody, is that it is making us have a privilege that the rest of the citizens of Texas don't have. And that's the problem I have.
So that's the policy consideration you gave it in terms of stripping this out?
That's right. If you want to have a debate on whether we should have one party, the one-party rule, or the two-party rule, fine. Go have that debate. But whatever you decide, it should apply to every citizen of the state of Texas. It should not create a special class that is the members of the legislature while we're in this building or on the Capitol grounds.
And was there any conversation when this was added in, or are you aware of any conversation about this component piece of the bill in the policy considerations of why it would be included? I'm just trying to...
I wonder why it's in this ethics bill, because everything we've been talking about is financial reports and things like that. It really is a different subject. So maybe it was just a bill looking for a ride.
Do we know if this was a separate bill?
I don't know.
Okay, thank you.
Representative Farrar, for what purpose, ma'am?
Will the gentleman yield?
Will the gentleman yield?
I will yield for some questions.
He yield.
Mr. Schaefer, your amendment strikes Article 5 from the bill, and this section states that a person has a justified expectation that the person's oral communication with a member of the legislature or the lieutenant governor while in the state capitol is not subject to recording without the person's consent, unless the person is communicating in a public hearing, correct? You're trying to strike that language?
I'm trying to strike that section because what that does is it carves out a special rule for members of the legislature which exempts us from the one-party
Only while we're here.
Rule and makes it to now where both parties have to have consent.
Okay, and that section also states that a party to a protected oral communication with a member of the legislature or the lieutenant governor while in the state capitol has a civil cause of action against a person who records the communication without the party's consent or who uses the recorded communication without the party's consent. Why do you believe this section or these sections are not necessary?
I'm not arguing one way or the other on you want to do the two-party consent system or the one-party consent system, okay? My point here is the public policy that whatever we decide should apply to every citizen of the state of Texas, and not just us. When I'm standing out there on the sidewalk of the Capitol, I'm no different than any other citizen of the state of Texas.
Have you yourself been approached during this session?
Sure I have.
Been asked
Yes.
questions and been recorded?
Yes.
What do you think the purpose of asking those questions is?
People have the right to record and under current law and ask their legislators what they're doing. So I don't know what someone's motivations are.
I was, when we broke earlier today for our caucus meetings, I was approached as I was walking up the stairs by a gentleman who asked me a question, and it wasn't the first time. And my response to him was, who's paying you to ask these questions? And every time he asked me a question, I asked him, who's paying you? And he never used that opportunity to respond to who was paying for him. And so what you were, explain to me in that situation that I went through, what my protections would be for someone who was accosting me with questions that had nothing to do with anything.
You don't have to answer the questions.
No, but with your removal of this language, what would that, what effects would that have to myself or to another member?
Be the current law.
Or you would be removing, though, the bill is trying to provide some protections to us.
Yeah, just to us, not to ordinary Texans.
For instance, this man would not respond to who was paying him to ask questions. He was not a member of the press.
When we get elected to office,
he was not a member of the public. He was not one of my constituents. Maybe, I don't know whose constituent he was, but he wasn't approaching me as a constituent with someone, or someone with an honest question. Had never contacted my office to ask for an appointment, or had contacted in some other way for a response to his question. So my question to you is that you're trying to remove a protection for members of the legislature that find themselves in a situation where people who are, we don't know who's paying them to ask these questions. You're saying that this is we should all be, you're cloaking this under equal protections from the public. Just a moment, let me finish my point. Is that you are saying that you're cloaking this under a guise that we shouldn't have different protections from the public. But the fact of the matter is, the elephant in the room is that someone is trying to get us into whatever their agenda is. I don't know. We don't know, because we don't know who's paying for them. And so you would allow, by removing this protection, you would allow those sorts of people to operate in this business in this building and disrupt the business of this legislature.
You know what? I believe that sunshine is a great disinfectant. And I believe that current law means that one party to the conversation has to be aware that it's being recorded. And we're public figures, and when we run for office, we sign up to get hard questions sent our way. And I don't mind that personally.
You can call it what you want to. So
I would leave it under current law. I would not change current law.
You can call it what you want to, but by removing this language, it would remove protections and allow those kinds of shady operations to disrupt the business of this body.
Well, if you believe that that's the way it should be, I will allow your argument. But then go file a bill and let us all debate it that applies to all citizens of the state of Texas, not just us.
You'd have a difficult time. Well, that's why don't you ask him?
Representative Moody, for what purpose, sir? Oh, sorry. Representative Giddings, for what purpose, ma'am?
Mr. Speaker, I suppose this is a parliamentary inquiry in that can we, on these amendments, have the page numbers, or on this one we don't, and to begin with, the amendment didn't apply to anything, and I want to be absolutely certain that we know exactly what we're striking, and sometimes without page numbers or line numbers, we don't.
Yes, ma'am. We'll look at the drafting of the amendments and see if there's anything.
That was my fault, Ms. Giddings, for starting out with the wrong amendment.
Thank you very much.
Mr. Speaker.
Representative Stickland, for what?
Does the gentleman yield for a question?
Does the gentleman yield?
I will yield for a question.
Representative Schaefer, what do we call this
Representative Stickland,
place?
for points of reference, you have about 45 seconds.
What do we call this place?
The People's House.
The People's House. And anyone that votes against your amendment, in your opinion, is it fair to say that they are voting to make this place darker, less transparent, and encourage more backroom deals that no one else can know about?
I believe that sunshine is a great disinfectant, and I believe that the current law that we have is a good one. It causes us to be accountable when we speak. We all say things we shouldn't at times, but the current law makes it so that we guard our tongue a whole lot more.
So a vote for your amendment is putting public officials in the People's House out there for everyone to see with no more secrets, correct?
Well, I believe that it keeps current law, and I believe if you leave this in the bill, you are restricting people's ability to question their legislators, and you're making legislators be a special class of citizen.
Representative Bodden raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Representative Stickland, for what purpose, sir?
I want a record vote on this issue.
Chair recognizes Representative Cook in opposition.
I'm going to speak against this amendment. And let me tell you, I've been here for 7 terms. Ms. Thompson, how many terms have you been here? The point is, this is the first session that we've ever experienced what we've experienced. And you talk about this people's house, and this is a people's house right here. And everybody can watch and participate. But chasing people back and forth between offices, sneaking up on people, that is not what this is. That's not what this should be about. It's never happened before. And by the way, these groups that do this, we don't even know who funds them because they are funded by dark money. And what's different about this session? Let me tell you, we got people that are up in the gallery from the time we get here to the time we leave with high-speed, long-range lens. I'll bet you Ms. Thompson's never seen that until this session. I bet you Ms. Riddle has never had to try to get away from people accosting her. It's never happened. And let me tell you, Mr. Miller, if you're walking to the floor and you have a constituent, do you know right now that conversation with that constituent is at risk? This is a dark and evil force that's on us now. And let me tell you, everybody here should vote against this amendment.
Does the gentleman yield for a question? Well, does the gentleman yield for a question?
Does the gentleman yield
for a question?
What are you afraid of
Gentleman
anyone
yields.
finding out in the people's house, Chairman Cook?
This is the people's house in here, chasing us
Then
all
why
around.
are you afraid of anyone? Why are you trying to put a muzzle on the press that are here? Why are you trying to put a muzzle on the people out here? Why are you doing that, sir?
There is no muzzle on the press. These are not.
You
this
want to
is not
know?
the
You want to
press.
give permission for someone to record you in the.
Members, the House will come to order. We will conduct ourselves in an orderly manner, and we will allow one another to speak. Chair recognizes Representative Cook.
Chairman
Mr.
Cook,
Stickland, for what purpose?
Chairman Cook, you can try and
Mr.
make this
Stickland,
about
for
one
what
group.
purpose?
Does the gentleman yield for a
Does
question?
gentleman
I yield
yield?
for a question.
Chairman
Gentleman
Cook, you
yields.
can try and make this about one group or one agenda or anything else. But the far-reaching effects of the legislation that you have added onto this bill is going to affect so many more people and have so many unintended consequences. And I believe the purpose of that is so that more people can hide what's really going on. And I think everybody should vote against this.
Mr. Speaker, will the gentleman yield?
Mr. Tinderholt, for what purpose?
Will the gentleman yield for a question?
Will the gentleman yield?
I haven't heard a question yet, but I'm glad to yield for one.
Gentleman yields.
Representative Cook, is it fair to say that people volunteer during campaign season in different ways, meaning financial, block walk, working with maps and paperwork? Is that a fair guesstimate?
Correct.
When does this tracking of names and people end? Should we be tracking who comes to volunteer and block walk for you?
I'm not sure what this has to do with the bill, but you can tell me.
I'm trying to walk the dog on this. At what point do we track what you call dark
I don't think
money?
this dog can walk, to be real honest with you.
I'm sorry?
I don't think this dog can walk.
You know, with all due respect, being a smart aleck does not work real well here. I thought we had decorum.
Members, the House will come to order. Please take your seats, take your conversations outside the rail. We will conduct ourselves in an orderly manner. Chair recognizes Representative Cook. Representative Marquez, for what purpose?
Vote no on the amendment.
Mr. Speaker, if the gentleman would yield for a couple of questions.
Will the gentleman yield?
Yes.
Gentleman will yield.
Mr. Cook, do you think it's appropriate that people that are not credentialed by the press to follow women around, to take pictures of them while they're traveling with their families or traveling home? Do you
No.
think that's an appropriate behavior for anybody to be under in this House, particularly the women in this House?
Absolutely not.
Have there been instances where people have been followed home or have been followed to the parking garage or have been followed to other establishments where they've been with their private families? Has that happened in this session?
You know, I've heard that's the case.
Do you think that's appropriate? Even though we are elected officials, are there not already mechanisms in place and provisions in place for open records requests They can get our emails if we're talking about state business. They can get our personal emails if we're talking about state business. And they can also request our text messages if we're talking about state business.
That's correct.
Do you feel that the provisions that we already have in place are enough for the public to know exactly what we are discussing amongst one another and with the public?
Of course we do. And remember, when we have public hearings, when we have committee hearings, it's open to the public. So everyone has a chance. And they can come and sign up, be for or against any bill. They can sit in here 24 hours a day and watch what we're doing. We're very transparent. But once again, I'm disturbed that suddenly, after all these years, suddenly this session, we now have people running around chasing people. And the worst part about it is we don't even know who's funding them, and we don't know why they're doing it.
I appreciate you defending this particular motion, Representative Cook, on behalf of the human beings. I think people forget elected officials are human beings, we're citizens, and we deserve to be protected and not threatened in our position in this House.
Mr. Speaker?
Representative Farrar, for what purpose,
Will the gentleman yield?
Will the gentleman yield?
I yield.
Gentleman will yield.
Chairman Cook, I don't know if you heard my exchange earlier with Mr. Schaefer about my experience just today. As I was going up the stairs to the third floor to the Supreme Court room, old Supreme Court room where the Democratic caucus met, a fella stopped me and kept chasing me up the stairs, asking me, I don't even remember what the question was, and it was very clear his intent was to it was sort of a gotcha moment. I did not see any credentials from the press hanging from his neck or any sort of thing. I did not know him as a member of the press, and he did not seem like just an individual who had an honest question and had a situation he needed addressed. This man had not contacted my office, but when I asked him in return, I said, "Who is paying you?" He would not answer. Who is paying you? He just kept repeating his question, and so he had an opportunity to say what his motives were, and he never did. And so, in these situations where we are going about our work and we are does your bill, that provision in your bill, it protects us as we go along in our work, correct?
Absolutely. And it's interesting to me that people would fight so vehemently against an ethic bill.
Correct. Why would, certainly you can just speculate, but why would someone want to remove, because it provides a civil action for us, and a lot of times that's just really a stick. It may never come to be anything, but it provides cause for someone to perhaps not engage in this sort of behavior. Would you agree with that?
Absolutely. And once again, in the history of this institution, we've never seen this happen until this session. And the reality of the fact is, members, if we don't rein this in, next session, it will only get worse. The following session, it will only get worse.
Representative
no
Lautenberg raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Chair recognizes Representative Fallon to speak for the amendment.
Members, thank you, Mr. Speaker. Members, I know that time is of the essence, and I'll be very brief. Coming off of City Council, one of the things that I love the most about the job is that every citizen at 7:30 p.m. in Frisco, Texas, on the first and third Tuesday of every month could come up and speak and citizens input for 5 minutes. And they could tell us that we're doing a great job or we're doing a horrible job, because that's what this country was all about. And I love that, because in many countries in this world right now today, they could smash your car or they'll burn your house down for doing that. That's the essence of what it is to be American. And that's why, yes, is this filming that's going on this session, is it annoying? Yes. Is it a game of gotcha? Yes. Do I like it? No. But that's what we signed up for, to run for office and to represent and have the privilege of representing 170,000 people. It is annoying, and it is a game of gotcha, and it is inappropriate, and particularly for the female members of this body. But it is legal, and it is, in essence, what it is to be an American. Thank you.
Chair recognizes Representative Farrar to speak against the amendment.
Mr. Speaker, members.
Members, the House will come to order. Please take your seats or take your conversations outside the rail. Chair recognizes Representative Farrar.
Mr. Speaker and members, I'm sure, like my office, a lot of your offices are, or all of your offices are, your door is always open. We are probably the most accessible public officials I can imagine. We have all sorts of ways that people communicate with our offices. They email, they call, they drop by our capital offices, our district offices and such. We trip over ourselves to find ways for the public to communicate with us, to respond, to be a part of this process. Many of us issue regular newsletters. I issue an electronic one every week about what went on in the legislature. So this is not about the public having access to us. What is happening is really a corruption of the process when you have people coming up to you, people who are paid. No one knows who's paying them. Perhaps some people do, but for the most part, we don't know who is paying these people to do this to us. And it's the most cynical action about when we're supposed to be having a democracy and an open process. So anyone that says that it's okay to have these people come up to you and that the common man should have the same protections, and so the common man does not have the resources to pay a group of people who are here all the time chasing us down. They know where to find us in the front hall. They know how to find us in the back hall. They've even found us down on the ground floor. And I've talked to some of our colleagues who have had someone a female jump into the elevator with them and just begin berating them with questions. They are professionally trained. They don't take no for answers. These are not people who are actually trying to do the business of the citizens of the state. They are paid guns for hire, and I would ask you to vote against the amendment.
Chair recognizes Representative Simpson for the amendment.
Thank you, Mr. Speaker. Members, I'm going to be very brief. I just spoke briefly with Chairman Cook to confirm this, but I do believe the bill as drafted would prohibit the disclosures of videos already taken during this session. And though some might like that to be prohibited, I do think that is contrary to the spirit and purpose of our Constitution of passing a law that would be retroactive. We've all sworn an oath to uphold that. I'd encourage you to vote for this amendment that would hold us to a high standard, that we could be held accountable for our words and our actions in any place. And thank you for your consideration.
Chair recognizes Representative Schaefer to close.
Current law protects you when it requires one party to be a member of the conversation. Current law protects you if you're being threatened. But what this bill does is create a special class of citizens, creates a special privilege for members of the legislature when we're on this Capitol grounds. If this is a good bill, if it's a good idea, then you ought to make it apply to every citizen of the state of Texas and not create a special privilege for the members of the legislature. And I close.
Representative Rodriguez, for what purpose?
I had a quick question, real quick.
Will the gentleman yield? Gentleman yields.
So your position is that that if you're a citizen of this country, really, you're here, that we shouldn't be a special class of citizen, and that if they want to record us, as much as we may not like that, that's within their right to do?
Well, my position is that if you're going to change the law to go to a two-party system, then you ought to make it apply to every member of every citizen in Texas.
So that not only it wouldn't be just us that they're prohibited from filming, right? That if you're going to prohibit it for everybody, not just for us.
That's right. If we're going to change the law to make that type of action something that you can file a lawsuit and get damages for, then it ought to be good for every citizen in the state of Texas.
Well, I hate to, it pains me to even say this, but I think I agree with you. I think this is one thing that we actually do agree on. I think that you're absolutely right on this. I don't like what's happening here any more than anybody else does. I actually do not like it at all, but it is their right to do so.
Thank you, Eddie.
Members, Representative Schaefer sends up an amendment. The This is a record vote. Vote yes, vote no from your desk. The clerk will ring the bell. Show Representative Cook voting no. Show Representative Schaefer voting aye. Show Representative Villalba voting no. Have all members voted? Show Representative Galindo voting no. Show Representative Isaac voting no. Have all members voted? Have all members voted? Being 66 ayes, 74 nays, the amendment fails to adopt. Following amendment, the clerk will read the amendment.
Amendment by Turner of Tarrant.
Chair recognizes Representative Turner of Tarrant. Chair recognizes Representative Turner of Tarrant.
Thank you, Mr. Speaker. Members, this amendment simply clarifies the reporting requirements on our personal financial statements for revolving accounts, including credit cards. And this amendment would clarify that only outstanding balances carried for more than 90 days must be reported. All right. And I believe it is acceptable to the author.
Members, Representative Turner of Tarrant offers up an amendment. The amendment is acceptable to the author. Representative Turner, for what purpose?
I'm sorry. If Representative Turner would come back, I was trying to read it, Mr. Speaker. Would the gentleman yield?
Will Representative Turner of Tarrant yield to Representative
Absolutely.
Turner of Harris? He
Thank
yields.
you. And explain it one more time.
Sure,
Turner.
absolutely, Representative Turner. This amendment clarifies that on our personal financial statements, we currently have a schedule for debts and outstanding loans.
Correct.
There is a lack of clarity right now in terms of revolving debt, revolving loans, including credit cards, whether those should be reported or not. For instance, when I first ran in 2008, and I was filling my form out for the first time, and I had a lot of questions. I called the Ethics Commission. I said, debts. I said, obviously, mortgage, I should report that, right? Yes. Car payment, yes, you should report that. So I said, I don't need to report credit cards I have, right? Because I pay them off every month. They said, no, you need to list all of your credit cards if you ever have a balance on them in the course of the year, which I thought was kind of odd. But that, and the Ethics Commission, as I've worked on this issue this session, the Ethics Commission agrees there's a lot of ambiguity right now with regard to credit cards. So what this amendment does that Chairman Cook has agreed to accept, it says that if you carry debt for more than 90 days on a credit card without paying it off, then it would be reported in terms of you would report within the amount brackets that we already have on the report.
Thanks. I just needed the clarification. Thank you very much.
You bet. Happy to do that. Move adoption.
Members, Representative Turner of Tarrant offers up an amendment. The amendment is acceptable to the author. Is there objection? Chair hears none, so ordered. Following amendment, the clerk will read the amendment. Representative Anchia.
Amendment by Anchia.
Chair recognizes Representative Anchia.
Yeah. So members, earlier in today's debate, the threshold for substantial interest was changed, and that was a definition in the government code in section 572.005 sub 2. And that is tied to what was then a 10% ownership or control being a substantial interest. So what we're trying to do in this amendment is harmonizing the substantial interest definition with the disclosure requirement that exists in the bill, and I believe it's acceptable to the author.
Members, Representative Anchia offers up an amendment. The amendment is acceptable to the author. Is there any objection? Chair hears none, so ordered. Following amendment, the clerk will read the amendment. Representative Davis of Dallas.
Amendment by Davis of Dallas.
Chair recognizes Mrs. Davis. Members, the amendment is being withdrawn. Following amendment, the clerk will read the amendment. Mr. Martinez. Following amendment, the clerk will read the amendment.
Amendment by Martinez.
Chair recognizes Representative Martinez.
Thank you, Mr. Speaker. Members, all this amendment does, it simply extends the protections included in the bill to our district offices as well. The need for open discussion with our constituents so that we can provide aid and guidance is just as important in our district's offices as in the Capitol. Under this bill currently, as it's written, the interception of certain oral communications made in the Capitol is prohibited in page 27, line 20. And we all know the reasons for this, and I agree that underhanded recordings are wrong and unethical. So whenever you have those discussions with your
Mr. Schaefer will be with you in just a moment. Mr. Schaefer, for what purpose?
And I believe it's acceptable to the office.
Mr. Schaefer, for what purpose?
Will the gentleman yield for question?
Will the gentleman yield? Gentleman yield,
Can I just make sure I understand your amendment? So this
yes, it just extends the protections that are currently here in the Capitol when we talk with our constituents down in our district office. The same protections we have here, the same protections we give them in the district.
So relating to the same issue that I had earlier.
Actually, this is different. This is what's already in the bill, discussing the protections with your constituents. With any type of discussions you have with them, you're just extending that down to the district office as well.
But this has to do with the two-way communication, correct?
Well,
this has to do with
it has the need for open discussion with our constituents so they can provide aid and guidance. When we provide them with aid and guidance, we just want to make sure that our conversations with our constituents are protected.
Okay, but this is the same issue. This now, the special privilege will not only apply in the Capitol, but the special privilege for legislators will also apply back in the district offices. Thank you.
Okay, and it's acceptable to the author.
Members, Representative Martinez offers up an amendment. The amendment is acceptable to the author, but record vote has been requested. A record vote is granted. Please vote from your desk. The clerk will ring the bell. Show Representative Cook voting aye, Representative Deschantel and Representative Harless voting aye. Show Representative Galindo voting aye. Show Representative Villalba voting aye. Have all members voted? Have all members voted? Being 98 ayes, 43 nays, the amendment is adopted. Following an amendment, the clerk will read the amendment. Ms. Hernandez.
Amendment by Hernandez.
The chair recognizes Representative Hernandez.
Thank you, Mr. Speaker and members. This amendment deals with the online filing system and states that a financial statement filed electronically may not be considered untimely filed if the Commission does not receive the statement before the applicable deadline as a result of a malfunction of the electronic filing system. Remember, before online filing, we had to submit. Prior to online filing, you had to have it postmarked, and that meant you had to get to the post office by 5 p.m. And as my predecessor left things for the very last minute, he would go to the airport because you could take it there a little bit later. But now that we're on online filing system, you have until midnight is my understanding. If you wait to the last minute and there's a problem with the online system and you can't file on time, this amendment will protect you from that, and I believe it's acceptable to the author.
Representative Wu, for what purpose, sir?
Would the gentlelady yield?
Will the lady yield? The lady yields.
Ms. Hernandez, I'm having a real hard time understanding your amendment. It's got like 2 or 3 double negatives in there. For those of us who are not like that familiar with the ethics rules, could you back up a little bit and explain exactly what is the current rule and what does this do to it?
So, for instance, if you have a filing deadline for our semi-annual reports of July 15th, and you wait
So this
until
is about deadline. This is about the deadline to filing.
That's correct. Whenever we're required to file our campaign finance reports, and we have until midnight to file it, you wait until 11:50. And there's a problem with the system and you can't file that until past the deadline, that you won't be...
Under the current rules, what determines the deadline?
I had the same questions when we went to online filing, because before it was postmarked, and as our personal financial statements, it's also a postmark. And I was advised that it's midnight. If the deadline is July 15th, it's up until midnight.
Okay. So how do they, I'm sorry, I'm just trying to figure out your amendment is, under the current rules, have they stated what is the system for determining when it's filed? Is it when they receive it? Is it what's marked in your email when you send it in?
Right, it's the electronic system that we all use, and you get a confirmation when you're filing it, and then you also get one sent to whatever email address you provide.
Okay, and so what does your amendment change it to?
It doesn't penalize you for not being able to file it if there's a malfunction with the electronic filing system.
Yeah, I will.
Members, Representative Hernandez offers up an amendment. The amendment is acceptable to the author. Is there objection? Chair hears none, so ordered. Following amendment, the clerk will read the amendment.
Amendment by Giddings.
Chair recognizes Representative Giddings.
Thank you very much, Mr. Chairman and members. This really is a one-word amendment. It says that a state officer or employee may not do certain things instead of should not, which is what it said in the past. This just has to do with the standards of conduct, and we're changing should not to may not. It's acceptable to the author.
Members, Representative Giddings offers up an amendment. The amendment is acceptable to the author. Is there an objection? Chair hears none, so ordered. Following amendment, the clerk will read the last amendment.
Amendment by Rinaldi.
Chair recognizes Representative Rinaldi.
Thank you, Mr. Speaker, members. Thank you, Mr. Speaker, members. The engrossed version of SB 19 as it came to this House was an ethics bill that passed the Senate unanimously that protects citizens from their government officials and makes our offices more transparent. The committee substitute that's before this House today is designed not to do that, but it's designed to protect elected officials from their voters. And that's what we have before us now. What my amendment does is restore the engrossed version that came to this House from the Senate and passed the Senate unanimously, and removes the provisions protecting us from our voters. The three most egregious of these provisions are, one, provisions that limit the political speech of grassroots organizations, of churches, of journalists.
Gutierrez, for what purpose, sir?
Will the gentleman yield?
Will the gentleman yield?
I will yield after, let me just finish my layout, please.
He does not yield this time.
Second, provisions that allow their legislators to sue their constituents who are recording them not only in the Capitol, but we just passed an amendment that allowed them to sue their constituents recording them elsewhere. And third,
It removes provisions from the Senate bill that would prohibit lobbyists from serving in public office. Ladies and gentlemen, this is a bill designed to protect us from the people. It's not designed to protect the people from us. And I'll yield.
What part of...
Representative Gutierrez, for what purpose?
Representative Rinaldi, what part of...
Gentleman yields.
What part of the protecting us from the people requires, or us protecting us, I don't even know where you're going with it, but what part is requiring drug testing? I mean, is this an emergency? You think that this is an emergency today, as the governor suggests?
I don't think an emergency item would have been put on the calendar for the last day. However, that's irrelevant to the point.
So you disagree with the governor that this is an emergency issue?
I don't agree or disagree.
Okay. So you have no opinion on whether it's an emergency?
I don't. What does that have to do with my amendment?
But someone suggested it's an emergency, right? Someone suggested it's an emergency, right? Not you.
I would presume it's an emergency item on the calendar.
Okay, so it's an emergency to someone. And yet, your bill seems to suggest that you want us all to take a drug test, right?
The engrossed Senate version, which passed unanimously, does have the drug test provision. I would be amenable to an amendment to the amendment that would eliminate that provision. Okay. I just think that instead of the House committee substitute, which focuses on protecting us from people, we should have provisions which increase transparency in our House.
Well, that's fair enough, because we can eliminate the next 10 minutes of questions on drug testing, because I have an amendment to the amendment which would eliminate drug testing. And I don't think that any one of us is doing any kind of drugs today, by the way. I'm willing to go take a piss test right now. But, let's be clear. I just find it kind of repulsive
bring your
that we
amendment
have to
down and it's acceptable to me.
Very good.
Representative Farrar, for what purpose?
Will the gentleman yield?
Will gentleman yield? Will
Gentleman yield.
Gentleman yields.
Does he yield?
Yes, ma'am.
Gentleman yields.
Your amendment is quite long. It's 15 pages, in fact. Is that correct?
Maybe. It's about that. It's long.
And it entirely substitutes the House version with the Senate engrossed version, correct?
That's correct, ma'am.
Why do you think that the Senate version is more valid than the House version?
Why do I think
came out
it's
of the committee that I sit on.
Why do I think it's more valid than the House version?
Mm-hmm.
As I set out, it's designed on increasing transparencies in this House. It's not designed to protect us from our voters, which is what the House version does.
Well, there was a specific, or was there a specific provision that you didn't like? I mean, you're saying that sort of blanket terms, but what is the specific provision that you say is protecting us from our votes?
Well, pretty much everything added by the House version that was substantive is designed to protect us from the people.
Could you give an example of that?
Virtually everything added by the committee substitute in the House.
Okay, that doesn't answer my question. I'm asking for detail. You made an allegation.
The camera provision.
The camera provision that we just debated that allows us to sue our constituents if they record us in the Capitol or our district offices. Provisions that limit the political speech of journalists, grassroots organizations, and churches that were found to be unconstitutional in NAACP versus Alabama in 1958. Provisions that allow the legislators to sue their constituents, who I talked about. Removing provisions which prevent lobbyists from serving in public office.
Mr. Speaker, will the gentleman yield?
For what purpose?
Yes, Mr. Chairman.
Gentleman yields.
Representative Rinaldi, I want to focus on the particular provision you're talking about in free speech. Are you objecting to having people that make political and campaign expenditures disclose their names and their information?
If they're coordinating with a candidate, then absolutely they should be required to disclose, and they are.
So, are you familiar with the Supreme Court opinion of McCutcheon versus Federal Elections Commission?
I'm not familiar with it.
Well, let me read to you what Justice Roberts said about the one issue that you're trying to put back into this bill, or take out of this bill, rather, about dark money and those groups that deal exclusively in that.
I don't know what dark money is.
Well, I'm about to educate you, okay. So then you can answer at the end if you would like. Justice Roberts stated in this April 2nd, 2014 opinion, disclosure of contributions also reduces the potential for abuse of the campaign finance system. This is the same man that dealt with Citizens United, as you well know, correct?
Correct.
All right. He goes on to further to say, disclosure requirements which are justified by a governmental interest in providing the electorate with information about the sources of election-related spending, then citing Citizens United, may deter corruption by exposing large contributions and expenditures in the light of publicity. So I know you voted a while ago for amendments that I think the phrase was, sunshine is the best disinfectant. Well, why can't we have some sunshine here, sir?
We should have sunshine here, and we should have sunshine on our expenditures. We should not require the citizens who are making independent campaign expenditures from having to disclose the political speech that they intend to make so that they can then be chilled in that political speech.
You cited a while ago the NAACP case. Do you know what that was about?
Absolutely. It was about disclosure of membership of the NAACP in Alabama.
And why did they not want to disclose their list?
Because it would chill the speech of that organization and subject their membership to harassment.
Mr. Rinaldi, sir, you're a much better lawyer than that. The NAACP did not disclose their list.
Members, we will maintain order and decorum. Chair recognizes Representative Rinaldi.
Thank you, Mr. Speaker.
Representative Olvera, for what purpose?
I would like to continue my questions, please.
Does gentleman yield?
Gentleman yields.
Gentleman yields.
Let's go back, perhaps more calmly, and talk about the NAACP case, which occurred in the 50s in the great state of Alabama. The NAACP did not want to disclose their members and their names because they were afraid of lynchings and church bombings and a lot of other things. In these recent Supreme Court cases, none of them have relied upon the NAACP case. Are you aware of that?
This particular provision hasn't been challenged, nor has one like it.
Yeah, and it hasn't been followed either. It hasn't been followed in any of these cases by the United States Supreme Court that has had to deal with the free speech argument. No one follows NAACP.
A speech provision like the one here hasn't been proposed, mainly because of the NAACP opinion.
And you know why?
Yes, because of concerns about the First Amendment violations that are proposed.
No, they actually put a standard in. If you go back and look at McCutcheon and those other Supreme Court cases that I assumed you would be familiar with, you would see that they said that you had to have express, hostile, retaliatory, things like that, raise that burden, not just because it's inconvenient or not just because you don't want to have somebody know that you're putting in millions and millions of dollars to impact the integrity of an election. Were you aware of that? Were you aware of any of these provisions that Justice Roberts and the Supreme Court laid out in response to your free speech argument denying the public access to the donors' names?
They weren't addressing the question on point over here. But yes.
I think the provision I read you, and I don't want to read it again, I don't want to be chubbing here, it's very clear that the Supreme Court said disclosure was appropriate as long as there was a governmental interest. And don't you agree with me that there's a governmental interest in the people knowing what money and where it comes from and how they're spending it and who's giving it?
There is a governmental interest in what money is being spent by public officials or in connection with public officials. However, independent organizations have the right to political speech.
Are you familiar
with... And that's what we're infringing on.
Representative Anderson of Dallas raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Following amendment to the amendment, the clerk will read the amendment.
Amendment by Gutierrez.
Chair recognizes Representative Gutierrez.
Thank you, Mr. Speaker. Members, it's my opinion that we don't need to get into, anybody's into the issue of drugs. Quite frankly, I think that this bill is about ethics. This is about making sure that we do right and we won't have conflicts. At the end of the day, I think that we are demeaning ourselves and demeaning our constituents by requiring us to take a drug test. Who would administer the drug test? You can go down this whole line And I think that, quite frankly, I just find it a little demeaning. We're public servants. The people in our communities trust us, and they know us. And so I think that this is a little bit overreaching, and it's my hope that my amendment is acceptable to the author.
Representative Wu, for what purpose?
Will the gentleman yield for questions?
Mr. Gutierrez will yield for questions.
I'll yield, sure.
Gentleman yields.
And Representative Gutierrez, I support your amendment to the amendment. The type of drug test that this calls, the bill or the amendment that Representative Rinaldi has filed, it calls for essentially it is a drug test without any prior suspicion. Is that right?
That's correct. That's correct.
So, in legal terms, we would usually call that a suspicionless search.
That's correct. Yeah.
Right. So, because what's going on is actually that we, or this body as the government, is searching everyone who has to take the test.
That's correct. It would be an unreasonable search.
And are there any constitutional provisions in the United States Constitution or the Texas Constitution that protects against unreasonable searches?
No, there's a Fourth Amendment in the United States Constitution.
Yeah. And in fact, the Fourth Amendment actually states that there will be no unreasonable searches and seizures. Is that correct?
That is absolutely correct.
And some of that is just a lot of that is intended to prevent us from being stopped at any moment, stopped at any time for any reason, whenever law enforcement or the state or the government feels like it.
That's right. That's right. Yeah, I think that for the most part, and it's my hope that the author will be accepting my amendment, but I think that for the most part that we're public servants, and while I may or may not agree with this ethics bill, we have put ourselves out there through disclosures time and time again, and we submit to whatever kind of disclosure that we have as to our financial, our income and whatnot. And we do it willingly, and everybody in this House accepts it because that is the law. And if this bill becomes the law, we'll accept it because that is the law. But I find it demeaning that we should even have the mere mention of drug tests. I think that the ultimate barometer as to character and integrity comes at the voting box. The ultimate barometer as to a person's qualifications, the ultimate barometer as to a person's skill set, the barometer as to their, even something that, could be hidden, like, for instance, drug use. I think that all of that shows through. I think that our constituents know what they're doing when they vote us into office, and so I find this a little bit overreaching, over the top. But I sense you have another question.
Do you know that the United States Supreme Court has already ruled on this issue?
No, I did not know that, but I'll let you illuminate.
In fact, in Chandler v. Miller, with the citation 52 U.S. 305, is a court decision by the United States Supreme Court in 1997. It's fairly recently.
That's correct.
It actually, the United States Supreme Court took this exact issue about whether or not a state can pass a law saying that we're going to drug test our members. Did you know that?
I did not know the holding in Chandler v. Miller.
Okay. The United States Supreme Court actually said that drug testing elected officials is no different than drug testing welfare recipients, and no different than drug testing anyone else. You have to have suspicion to search. The Constitution does not change just because you're an elected official. You're protected by the same rights and the same protections as everyone else.
No, I believe in the holding in Chandler v. Miller. And again, the idea that we should be subject, if the law said I had to do it, I'd do it right now. I mean, I have no problems. I don't do drugs, never have, never will. I didn't inhale because I never did it. And there are other people Now I don't think that they want to take this, but that's fine. We can vote on this. We can make this bill even worse. That's fine.
So, I mean, in fact, if this amendment doesn't go on, potentially it could be, this whole section could get struck down if challenged in court.
Well, let's be clear. If this amendment doesn't get accepted, let's be clear. Can I do another amendment to the amendment? I will have another amendment, a separate amendment, requiring, and I hope the folks behind me are listening, requiring it to be a Class B misdemeanor if anybody uses a substance to hide their urine. Now, we can go down that path. We can accept this amendment because it's a farce. It's a travesty, excuse me. It's a travesty, and it demeans us as a body. It demeans us as public servants. But if this amendment is not accepted, we will have another 20-minute conversation about devices and chemicals that are used to hide your urine. And we can have that discussion right now about products that are used to hide your urine and to camouflage it as if it was clean urine.
What about using someone else's urine?
Often done by probationers in our county courts and such. It happens. It happens.
Would you include that in your amendment as well?
I would talk about that, and we'll talk for another half hour, maybe an hour, on different products. There's a product called the Whizzinator. Ever heard of that?
Yes, I have.
Piss tests, I think they call them, some defendants. We can talk about all those things for about another hour. I think amendments to the amendment to the amendment. God, we just have all sorts of things just on crime and punishment and going to the bathroom. And by the way, who administers this test? Who gets to watch me urinate?
Representative Rinaldi raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Representative Gutierrez offers up an amendment. The amendment is acceptable to the author. Is there objection? Chair hears none, so ordered. We are back on the Rinaldi amendment. Would anyone like to speak on, for, or against the Rinaldi amendment? Representative Anchia to speak against the amendment.
No, not so. On.
Representative Anchia to speak on the amendment.
Thank you, Mr. Speaker and members. You know, many of you probably don't know this about me, but I was a law professor at Texas Tech University back in the spring of 2000. I was an adjunct, as it's true statement, sir. And there appeared to be a little bit of confusion related to NAACP versus Alabama on the debate at the front and back mic. So I'd like to share some of my thoughts on that case and maybe allow, it might change the way you reflect on this amendment. So National Association for the Advancement of Colored People versus Alabama, 357 U.S. 449, it was decided in 1958. It's one of the most important civil rights cases that's ever been brought before the United States Supreme Court. Most law students study it at some point. This is where Alabama sought to prevent the NAACP from conducting further business in the state. And after the circuit court issued a restraining order, the state issued a subpoena for various records, including NAACP's membership list. And the Supreme Court ruled that Alabama's demand for the list had violated the right of due process guaranteed by the 14th Amendment to the U.S. Constitution. So let me give you a little bit of background on how they got to that holding. In 1956, the Attorney General of Alabama, John Patterson, brought a suit to the State Circuit Court of Montgomery, Alabama, challenging the NAACP for a violation of a state statute requiring foreign corporations to qualify for doing business in the state. Now, the NAACP members, which was a nonprofit membership corporation based in New York, had not complied with the statute, as it believed it was exempt. The state's suit sought to both prevent the association from conducting further business within the state and indeed to remove it from the state.
Representative Oliveira, for what purpose, sir?
Referring to the association's involvement...
Will the gentleman yield, or when he's finished, will he yield, please?
I'd be glad to, and I'll be wrapping up shortly. I'm trying to be quick on this, but I really do want people to get... I want people to have the background requisite to follow the discussion that you were having from the back mic. But referring to the association's involvement with the Montgomery bus boycott in 1955 in its role funding and providing legal assistance to black students seeking admission to the state university, the suit charged that the association was, quote, causing irreparable injury to the property and civil rights of the residents and citizens of the state of Alabama, for which criminal prosecution and civil actions at law afforded no adequate relief. So I will fast forward, members. The association was represented throughout by Robert L. Carter of the NAACP Legal Defense Fund. And he responded by moving to dissolve the order on the grounds that its activities within the state did not require its qualifications under the state statute. So the U.S. Supreme Court, when it got to the Supreme Court, they reversed the first contempt judgment from the Alabama Supreme Court and later decided in an opinion delivered by Justice John Marshall Harlan II, they decided in favor of the petitioners, members, holding that, quote, immunity from state scrutiny of petitioners' membership lists is here so related to the right of petitioners' members to pursue their lawful private interests privately and to associate freely with others in doing so as to come within protection of the 14th Amendment, end quote. And further, that freedom to associate with organizations dedicated to, quote, the advancement of beliefs and ideas, end quote, is an inseparable part of due process under the 14th Amendment. The action of the states obtaining the names of the association's membership would likely interfere with the free association of its members, so the state's interest in obtaining the records was superseded by constitutional rights of the petitioners. And that, members, that is NAACP versus Alabama.
Mr. Speaker, will the gentleman yield?
For what purpose?
Will the gentleman yield?
Will the gentleman yield? Gentleman yields.
I do.
Professor Anchia, thank you for laying out the opinion because you did an excellent job. The big issue, though, is there a compelling government interest, a substantial government interest, to allow for disclosure of the names of these donors of dark money, even if they go to front facade groups? That's the issue in this ethics bill. You agree?
Yes, I do.
And is there anything in the NAACP ruling or in any subsequent Supreme Court rulings that has said the disclosure of that information since that time, limited to that one instance when African Americans were facing being lynched, churches burned, economic retaliation, and over and over and over, does that compare to the Koch brothers being a little bit concerned about maybe their name is going to come out in some list?
I think it's apples and oranges, frankly. And to try to create the parallel, as you correctly point out, between NAACP versus Alabama and hiding donors' identities behind corporate
shadows. And why is dark money bad? Let's have that conversation.
Well, so here's the deal. If my mother gives me $51 in cash as a donation, I must disclose her name. I'm required to do so. But using these veils of darkness, you can have undisclosed money, virtually unlimited undisclosed money, be funneled into politics. And that's bad. You know why? Because that $51 donation to me, the public is able to understand it and see it and then evaluate my message and how I might be influenced by that $51 donation. But the public has no idea what money is behind other messages when they're in the shadows, when they're not disclosed.
And there could be hundreds of thousands of dollars, in essence, in our races as representatives, and in other races it could be millions of dollars that the public does not know where it came from, who it came from, what their agenda is, and how does that put any sunlight on the elections process and giving our voters a chance to know where this money's coming from, who's giving it, and what motive they may have when everybody else has to disclose.
And sunlight is the key, right? Because in order for constituents, for voters to be able to evaluate the message, they have to know what is behind it, because all these groups have great names, you know, liberty and happiness and all good things, and they all sound real good. But unless voters really know who's behind that message, can they really evaluate the motive behind that message?
Were you aware that we heard testimony in the interim about a case in Utah where apparently hundreds of payday lenders set up different kinds of nonprofits, funneled money to one particular attorney general candidate, and in Utah this was a big amount, several $100,000, and they did it all through these so-called nonprofit groups who did give themselves like, we're good government and we're freedom for education, and it had nothing to do with that, and all the money came from payday lenders to support one corrupt attorney general who subsequently was ousted from office.
And that's why relying on the NAACP versus Alabama case really doesn't fit here. It is not precedent for what the underlying bill does. This underlying bill tries to shine light in dark corners in the political process, and we should be supporting it.
Well, and one last thing. The bill that Chairman Cook has, it doesn't even deal with that $51. You can spend up to $2,000 and you don't have to disclose it. So those little folks out there are not going to be affected. It's going to be these large corporate donors or rich billionaires who want to simply control the political fabric of the state of Texas. Were you aware of that?
That's right, Mr. Chairman.
Representative Lautenberg raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Chair announces the signing of the following in the presence of the House.
SB 983, SB 1032.
Chair recognizes Representative Farrar to speak against the Rinaldi Amendment.
Mr. Speaker and members, this bill, the one you have before you, not the amendment, understand the amendment guts the bill and replaces it with what came out of the Senate. What you had before you, what is on our calendar as the bill, is what came out of our committee was after many, many negotiations, and there have been some allegations that the Senate engrossed version had more protections. But let me tell you, let me make sure that you understand. In the bill, in Chairman Cook's bill, it has that personal financial statements, as you know, have to be now submitted electronically. But in those, we're going to beef up those statements, and I think it's important. And these are, it closes some loopholes and it patches some places that there have been problems. It will require all of us to disclose information about referral fees paid to a firm or an entity with which the filer has a substantial interest. It will require us to disclose information on contracts with public entities and paid relationships with public entities. It will require disclosure of information on any other source of income, including federal or state governmental disability payments or other public benefits. It also includes pensions, individual retirement accounts, and other retirement plans. It requires, we must also affirm, and I think this is an important piece, listen here, that the individuals, that all of us have filed a federal personal income tax return and have paid all taxes owed, or if we have filed an extension. And also whether or not we have paid all of our property taxes. These are things we have to affirm. And also, a state officer who provides advice or assistance relating to a government contract must report the name of each person to whom the officer provided the services and the category of the amount of compensation actually received. And finally, even a nominee for an appointment by the governor, lieutenant governor, or speaker must disclose any political contributions made during the 2 years preceding the individual's nomination by the nominee or the nominee's spouse to the appointing officer. So to say that this bill is a watered-down version is not the case. what is really at stake here is we are cleaning up the system for us. I think this has been a systematic process, actually, since I've been here. And, but I think the elephant in the room is that the difference is if you vote for the amendment, you're protecting the dark money, and if you're not, we have a good bill before us. Yes, I will yield.
Representative Reynolds, for what purpose?
Yes, would the gentlelady yield?
Will the lady yield?
I will yield.
Lady yields for
Thank
questions.
you. Representative Farrar, from what I'm hearing from you, it sounds like that your amendment is to provide more transparency and openness in the process. Is that correct?
Well, the Chairman Cook's bill does do that. The amendment, though, takes us back to the Senate version that protects people. I know there's been a lot of discussion about that, so I won't go into that any further, but it protects people who don't have to disclose bottomless amounts of money into this process that are not political committees.
And could you tell the body what is your intent? What are you trying to what are you trying to see happen?
I want to make sure that the membership understands that Chairman Cook's bill is a good bill. It came out of my committee. It was deliberated for weeks, and so there were a lot of parties that participated in these conversations, and we made it a better bill. And so what this would do would go back to the Senate engrossed version, which doesn't have. It doesn't have the protections against the dark money that Chairman Cook's bill has.
And so basically, from my reading of and listening to Representative Cook's bill, it adds a lot of protections and a lot more transparency than the Senate version.
Right, despite the claims to the contrary, that is correct.
And
that's why I gave some of these examples. I can give you more, but these are just some.
Could you give me a few more examples?
Pardon me?
Are there any more examples that you could give?
Sure. For instance, the commission, it goes on and on. Let's see. There are, did I mention the electronic filing? I think that's important that it's compulsive now. The commission shall make the personal financial statements available in a searchable format, and I think that's important because right now it's difficult. So it will be in a searchable format to the public on the commission's website, and this is not later than the 3rd business day. So I think that's pretty quick turnaround. Of course, our home addresses will be removed before making this statement available on the website, and also a filer may request that the financial statement be removed after the 2nd year, but it is up there as well. Also, there are remedies for conflicts of interests. Mr. Chairman wants to speak.
Those are great points. I'm glad you highlighted those. I think the body needed to hear some of those additional points, and I think this is a great, comprehensive bill, and I look forward to supporting it. Thank you.
Well, yes, vote for Chairman Cook's bill.
Yes.
To do that, you will have to vote against the Rinaldi amendment.
Absolutely.
Chair recognizes Representative Cook to speak against the amendment.
Thank you, Mr. Speaker. I want to thank the 124 members who signed on to House Bill 37, which was the bill to rein in dark money. And just to let you know, if you vote for this amendment, you're voting against the very thing that House Bill 37 represented. And I just want to leave you with this. The right to free speech and the right to participate in the democratic process are two of the most fundamental freedoms. To protect them, we need a requirement of full disclosure of all campaign contributions, including in-kind contributions and expenditures on behalf of any electoral activities, including those in the context of membership communications. Ronald Reagan, 1988 administrative message to Congress. So members, please vote against this amendment.
Chair recognizes Representative Rinaldi to close.
And HB 37 died. And HB 37 died on the calendar. This is a separate bill with a separate purpose. True ethics reform means transparency for government and privacy for citizens. I ask you to vote yes on the amendment, which will restore the Senate engrossed version. Good job.
Members, Representative Rinaldi sends up an amendment as amended. Representative Cook does not accept the amendment. The question is on the amendment, up and down. Clerk will ring the bell. This is a record vote. Show Representative Cook voting no. Show Representative Rinaldi voting aye. Have all members voted? Have all members voted? Show Representative Morrison voting no. Have all members voted? Being 33 ayes, 113 nays, the amendment fails to adopt. The following amendment, the clerk will read the amendment.
Amendment by Simpson.
Chair recognizes Representative Simpson.
Thank you, Mr. Speaker. Members, I would appreciate your close attention to this amendment. It concerns page 6, line 6, through page 7, line 4, which strikes it. What this amendment does is strikes a section that would criminalize citizens who use a computer or enter into contract with someone to use a computer to robocall us. And if you look at the language there on page 7, with legislative advertising. And it makes it a Class B misdemeanor. This is incredible that we use computers all the time in our campaigning to call our citizens, to ask them to vote for us, or to find out what they think. But if they call us, they call our offices, they're made into criminals. I don't know how this got into the bill, but this is incredible, and this makes us a very special class, very protected. And I urge you to support striking this section of the bill.
Representative Bonham, for what purpose, sir?
Ask Mr. Simpson a question or two.
Will the gentleman yield?
I'll yield for some questions.
Gentleman yield, sir.
Mr. Simpson, we've spent most of the day trying to figure out how we can get to bills that would help save lives.
And I would like to do this.
Protect our Second Amendment rights. So I'm just curious as to what we think we're accomplishing at this point, Mr. Simpson.
I think we're striking a very important section that would make criminals out of citizens.
So do you think this section is more important than saving lives and our Second Amendment rights,
we asked
Mr.
Chairman
Simpson?
Cook to postpone the bill, but he didn't want to do that. So I move adoption of this amendment.
Representative Wu, for what purpose?
Will the gentleman yield?
Will the gentleman yield?
Yes, I'll yield.
Gentleman yields.
David, you understand there's a big difference between one person calling a couple of hundred people and then one person calling another person 100 times.
Or one person contracting with a computer to call 10,000 people. And are using a computer to call us many, many times. That can be true.
You understand there's a difference between one person contracted with another to call 1,000 people one time versus you're contracting to call one person 1,000 times.
Well, that could be true, but we don't make it a criminal act. I don't think if we do that.
You know, if you called somebody 1,000 times, we would charge you with something already.
Yeah. But this doesn't require that it be 1,000 times. It just says if they call us with legislative advertising. They only have to call once, and they're a Class B. They violate the law and are subject to a Class B misdemeanor.
I mean, I think the point of this was directed at people who are using automated systems to blow up our phones.
Well, it just requires one call, not 1,000. And we're making them criminals for making their intent.
Does your amendment cut it back to that, or
no?
You just strike the provision completely.
I want to make sure it's out.
Your amendment just strikes the provision completely.
That's correct. To make us a special class of citizens.
Members, this amendment is out of order. We've already adopted an amendment that has struck in this section. Following amendment, the clerk will read the amendment.
Amendment by Bernal.
Chair recognizes Representative Rinaldi. Representative Bernal.
Thank you, Speaker. Members, if I could have your attention for a minute, this is actually a good amendment. I'm not here to spend or waste anybody's time. These bills are an opportunity for us to make good law, and in my opinion, this amendment makes this bill better. The amendment gives the person filing online the ability to affirm that the original report was made in good faith, without an attempt to mislead or misrepresent information contained in the report by offering an online affidavit. It's an extra level of protection, it's an extra level of transparency, and I'm certainly aware that you are familiar with this phenomenon in your own races. You know for a fact that when you've done your campaign finance report, you are looking at the other ones, your constituents are looking at them when they're filed, and the press is looking. And often what happens is that after the campaign filing deadline, the next day or a few days after that, all of a sudden, your opponent or another group suddenly has more money than they disclosed on the deadline. In my own race, just a few months before this, we had a campaign filing deadline. The day came and went, and the very next day, my opponent had $10,000. So, this is something you're all familiar with?
Representative Blanco, for what purpose, sir?
Will the gentleman yield?
Will the gentleman yield?
Yes.
Gentleman yields.
Okay. Okay. Representative, do you think, do you believe this electronic affidavit would hold members to a higher standard? Is another? I do, and what I've just learned is that the author of the bill agrees, and it's an acceptable amendment. So I appreciate that very much. And you think this is just another level of accountability for organizations and elected officials? It's a more accountability for office holders, for candidates, and organizations. Absolutely. Great. Move passage. Thank you.
Members, Representative Bernal offers up an amendment. The amendment is acceptable to the author. Is there objection? Chair hears none, so ordered. Following amendment, the clerk will read the amendment.
Amendment by Turner of Tarrant.
Chair recognizes Representative Turner of Tarrant.
Thank you, Mr. Speaker. Members, as you all know, candidates and office holders under current law cannot convert political contributions to personal use. That means anything we spend our campaign funds on has to be spent on our campaigns or office holder expenses. But when we leave office or campaign ends, what happens to things we've purchased with campaign funds? And under current law, those things cannot be converted to personal use. So if you have bought a television for your office, I can't take that TV home and put it in my living room afterwards. That's what the law says. But obviously, this is really hard to track. We don't have a system for tracking it. So what this amendment would do is just create a log that would be a schedule in the Texas Ethics Commission report to track property and make sure it's not converted to personal use, and provide a schedule to show how it's disposed of. So if you give a bunch of your campaign stuff to Goodwill when your campaign's over, to local, you donate it to a nonprofit, then you've got then you show where that property went. That's all that does. The threshold amount in the amendment is $250 or more. I was just talking with Chairman Cook. We might look at adjusting that to make it less.
Representative Collier, for what purpose?
Will the gentleman yield for a question?
Will the gentleman yield?
Yes, I'll yield.
Gentleman yields.
Representative Turner, thank you so much for this amendment. I just want to make sure that I can wrap my head around it and understand what you're attempting to accomplish through this. So there are times in our campaigns where we have to make purchases to further the progress of our campaigns, and I think you mentioned a television.
Absolutely. Yes.
And in fact, there may be times where you need to purchase a desk.
Sure.
And these items may be more than $250.
That's right. I know in my campaign I try to find old used furniture that probably is not worth $25. So, but yeah, you know, when you get into like a TV or you know, computer, you know, for example,
oh yes,
those are some higher dollar items.
Or phones, cell phones.
Sure.
Okay, and so the purpose of this particular amendment is to require the candidate or office holder to retain the receipts?
No, not necessarily receipts. It requires a retention schedule on our Ethics Commission reports. So property assets purchased by the campaign in excess of, under this amendment, $250. And so it just shows a retention schedule of assets owned by the campaign. And then if you know, let's say you bought a laptop in your campaign, and it's been a few years and it's outdated, you go get a new one, and you get your old laptop and you donate it, say donate it to, you know, Mission Arlington, for instance,
sure.
You know, near both of our
it's
districts.
It's a great organization.
Then this schedule would show, would provide a place for you to say, this asset was donated, is no longer an asset of the campaign.
So if you bought it in 2015 and you kept it in 2016, and on the 2016 report you put down, I had a couch or sofa, and I still have that sofa in 2016. And then if you donated in 2018, you would make the note of that, and then if you purchase another sofa after that, it would be noted in 2019, just so it doesn't look like you keep buying the same item over and over
right,
again.
exactly. It would show that it would not look like you made additional purchases. No, it would just be you report each item.
Okay, thank you so much for clearing that up.
Absolutely.
I appreciate that.
I'm sorry.
Representative Howard, for what purpose?
Would the gentleman yield for a question?
Will gentleman yield?
Yes, I'll yield.
Gentleman yields.
Thank you, Mr. Speaker. Representative Turner, we are currently, by statute, forbidden from using campaign funds for personal use, are we not?
That is correct.
And is your amendment then seeking to increase the transparency of how items that are accumulated during the course of a campaign are disposed of when the elected official is no longer serving, so that there can be no question about the fact that that person is using what they acquired through the campaign for personal benefit?
That's absolutely right. That's the intention of the amendment.
And right now, there's nothing that exists that gives that kind of transparency, is there?
No, there's really not, and that's the thing. You know, if someone buys a car with their campaign, which is allowed if you use it for political use, office holder use, you leave office. Well, what happens to that car? What happens to that vehicle? And this would ensure that we have a mechanism in place to track those major purchases.
So, if we want to honor the requirement that we do not use campaign funds for our own personal benefit, and assure those who made those contributions, as well as anybody else who's paying attention and is interested in what we do with those funds that we have taken in for specific purposes that are spelled out, not to be used for personal benefit, to assure those folks that these items that have been acquired are not being used by us once the campaign and the elected period of time is ended, then this is the way that we can do that. And nothing exists like this now, so it would be a significant increase in the transparency about that, would it not?
It would be a significant increase in the transparency for the public. And I would also add, it would also be a protection for candidates or office holders, in that if you, as we often do, you may have a campaign asset. I use the example of an old computer or a printer or something like that, and you go and and if you donate it to a not-for-profit in your district, say, and you did a good thing for that, but then someone say, well, I don't know that you donated it. How do I know you didn't take it home?
Right.
And so this provides, I think, a protection for us, and I believe it is now. No? She just told me. Okay. Sorry, had the wrong information. Apparently it's not acceptable.
Well, it makes a lot of sense to me, and I know Chairman Cook has some very good things in his bill. I wish that this would be a part of it. I think this is a very good addition, and I appreciate your bringing the amendment. Thank you.
Well, thank you, Representative Howard.
Thank you. Mr. Speaker?
Representative King, for what purpose, sir?
Will the gentleman yield for a question?
Will the gentleman yield?
Sure.
Gentleman yield, sir.
Thank you. So this requires any candidate for office. Is that constables, state officials, or anybody, or which candidates?
Under this bill, it would be anyone who's filing reports with the Texas Ethics Commission.
Okay. Anybody that has to file a report with the Texas Ethics Commission.
Correct.
So that wouldn't be your local candidates because they file with your county clerk.
County level, that's right.
I see. And you have to report the retention of any assets in your campaign over $250.
That's correct.
So if I bought $1,000 worth of bumper stickers and I gave out half of them, then I still have half of them, so I have to report that I still have $500 worth of bumper stickers.
No, that's a great question. The intent of this amendment, I'll make this very clear, is an item acquired. So a bumper sticker, one bumper sticker is not worth $250. That's, printing, things like that, where you might have a bulk purchase in excess of $250. That would not be, the intent would not to be include that under this amendment. We're talking about things like a television, a computer, a printer, a vehicle, things of that nature.
Well, why would you have to report those things and not something that you spent $1,000 on or $500?
I'm sorry, I didn't hear you, Mr. King.
I'm sorry. Why would you need to report a printer that you had who had obviously depreciated in value versus $1,000 worth of bumper stickers and you'd given half of them and you still had $500 worth left?
Sure. Well, the intent of this is to get to make sure we're enforcing our current law, which says that candidates can't convert campaign contributions, political contributions, to personal use. And so bumper stickers or letterhead, I don't think we can convert those to personal use. You can buy a flat screen TV and take that home in your living room and you're converting it to personal use. That's what we're trying to get at here.
Representative Lautenberg raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained. Chair recognizes Representative Cook.
Members, I'm going to ask you to vote no on this. I'm like Chairman King. I'm not sure how you're going to figure out how to value something that's gone down dramatically. I think it can create a penalty opportunity that wouldn't be good, and I'd ask you to vote no on this amendment.
Chair recognizes Representative Turner to close.
Thank you, Mr. Speaker. Members, again, I think this has been pretty well discussed, but I think this provides an added level of transparency for our constituents, for the public, to see when we use our campaign accounts to make legitimate purchases in connections with our political campaigns or our office holder responsibilities, that we're keeping track of what those assets are, and we're making sure that we're not in any way inadvertently or purposefully converting them to personal use. And this simply provides the transparency to enforce that. And again, I would reiterate, it adds a protection for everybody. So if you have purchased a vehicle for campaign use to drive around your district, and then you donate it to, the Kids Academy that always does the car donations, and which is a good thing to do. But if you do that and it's not reported somewhere, you could be accused of, hey, where did that vehicle go? How do I know you didn't, give it to your son, give it to your grandchild? This just protects us and provides a greater level of transparency by showing what those assets are that you purchased with political funds, where they've gone, and does your campaign still possess them? I think it's a reasonable measure to enforce our already existing law that strictly prohibits converting political contributions to personal use.
Representative King, for what purpose, sir?
Will the gentleman yield?
Will the gentleman yield?
Yes, I'll yield.
Gentleman yield, sir.
And you may think this is a frivolous question, but in my part of the world, a lot of people, they'll buy not only bumper stickers, but they'll buy lots of political signs, the 4x8 pieces.
Sure.
Yeah, and then
we do that too.
If they lose their campaign, they still have a campaign account open, and it's not unusual for some of those people to use those 4x8 signs for a lot of other things, the ones that are left over. They use it to build pens for their roosters, for all kinds of things on the side of their house, the side of their barn, and things like that, because they're waterproof. Would that be now a criminal penalty?
No, I don't think so, Mr. King. And listen, we use those signs a lot in North Texas too, and I've seen them used as sleds when we occasionally get some snow, and
exactly.
Kids love them. But this is property $250 in value or greater, I would view a 4x8, not the total number of, say, 4x8 signs that you purchase, that may be a couple $1,000s, but property as in one 4x8 sign is, what, $25 or something like that. That's not going to fall under
as long
this.
as they didn't use more than 10 of them, which would be 10 times 25, $250.
I understand. I think that I'll make very clear my intent is not something incidental like that, a sign, a bumper sticker, a piece of letterhead, things like that, old envelopes. But these are high dollar items such as electronics, vehicles, and so forth.
That's your intent? I see.
That is my intent. I'll be happy to move to put that in the journal.
Were you interested in an amendment to the amendment to clarify your intent?
I'd love to do an amendment to the amendment to make that clear.
I'll think about that.
Okay. Well, Mr. King, do you want to do it? Because I'll pull this down. Otherwise, he's going to.
I'm sorry?
Would you like me to withdraw this? And do you want to bring an amendment to the amendment? Or?
No, I don't have one prepared.
Okay.
Thank you.
All right. Thank you, members. I appreciate your support on this amendment. I urge you to vote yes on the amendment.
Members, Representative Turner of Tarrant offers an amendment to Senate Bill 19. This is a record vote. The clerk will ring the bell. Vote yes, vote no. Show Representative Cook voting no, Representative Turner voting aye, Turner of Tarrant voting aye. Show Representative Galindo voting no. Have all members voted? Show Representative Burkett voting no. Have all members voted? Have all members voted? Being 40 ayes, 105 nays, the motion fails to adopt. Following amendment, the clerk will read the amendment.
Amendment by Vo.
Chair recognizes Representative Vo.
Mr. Speaker, I move that we have the conversation between Representative King and Representative Turner put recorded.
Could you please make that motion here in just a few minutes? Your motion's out of order at this moment. Will you make it again here in just a minute? Thank you, sir.
No, not you. Got this last one. Hurry up.
Chair recognizes Representative Vo.
Acceptable?
Yeah.
Okay. Thank you, Mr. Speaker and members. What this amendment does is, I just want to clarify what political contribution means. It means a campaign contribution of an office holder contribution. And I just want to make sure that it is essential that when we accept political contributions, we do not feel obligated to especially treat any contributor. It is also essential that contributor knows that we as legislators are not expected to treat any more better than anyone else. And with that, this amendment is acceptable to the author.
Members, Representative Vo offers up an amendment. The amendment is acceptable to the author. Is there any objection? Chair hears none, so ordered. Members, Representative Keogh moves that the remarks between Representative King of Uvalde and Representative Turner of Tarrant on the Turner Amendment be reduced to writing and placed in the journal. Is there objection? Members, is there any objection? Chair hears none, so ordered. Members, is there anyone wishing to speak on, for, or against Senate Bill 19? If not, Chair recognizes Representative Cook to close.
Thank you, Mr. Speaker. Members, I hope that everybody will join me in voting for this emergency item, which the governor's asked us to work hard on. Vote yes on this bill.
Members, wait 1 second, please. Representative Farrar, for what purpose, ma'am?
A parliamentary inquiry.
State your inquiry, please, ma'am.
There were, I don't know, maybe 15 amendments left on my FAST screen.
All the amendments have been withdrawn, ma'am.
Okay, that wasn't reflected on the FAST.
Well, they will still show up. They'll still show up in the submitted amendments, ma'am. But they've been withdrawn. But they'll still show up as submitted.
I see.
Members, question occurs on passage of Senate Bill 19 to second reading. A record vote has been requested. A record vote is granted. The clerk will ring the bell. Show Representative Cook voting aye. Representative Galindo voting aye. Show Representative Raymond voting aye. Have all members voted? Show Representative Keffer voting aye. Have all members voted? Have all members voted? Being 96 ayes, 48 nays, Senate Bill 19 passes to third reading.
Mr. Speaker.
State your inquiry, please.
Parliamentary inquiry.
State your inquiry, please, sir.
Are we going to be moving on to postpone business at this point in the calendar?
The chair is about to lay out as a matter of postponed business Senate Bill 206.
Excellent. Appreciate it.
The clerk will read the bill.